Good morning and welcome. I'm Ned Foley, and together with my colleague Steve Huffner, our election law program here at Ohio State is pleased to convene this gathering to discuss the risk that the outcome of this November's presidential election might be unresolved and maybe more than just a few days. Originally, we had hoped to have this gathering in person. In fact, we had picked out a really cool room here at Ohio State for that purpose. It's a round room. It's called the Round Room. And the idea was to have a genuine roundtable discussion. We put a real round table in the middle of the room for a seminar style format, and then the audience would be seated on the perimeters of the room, as you can see in this photograph. So obviously we're not there in that room physically today, but we're hoping to replicate as much as possible the feel of that room and a genuine roundtable seminar style discussion. We've got a great group of people that will participate. I'm not going to read all of their bios. That would take way too long. The bios are all available on the web page associated with this event, and you're welcome to peruse that during the scope of in the course of today's conversation. This is really a brainstorming session designed for as much creative thinking on our topic as possible. There's no script. Steve and I don't have any intended destination for where this conversation is supposed to end up. At the end of today and in the aftermath, we're going to take stock of what's been said today and figure out whether additional work on this topic should be done, perhaps by us here at Ohio State, perhaps by others elsewhere around the country, with the goal of addressing these issues to avoid problems. The idea of discussing these things now is to reduce the risk of problems that might occur in November. And in that regard, I want to mention one thing. Many of you know that last week, the University of California at Irvine, under the leadership of Professor Rick Hasen, is with us today, issued a really important report with a multiple set of recommendations for how to help prepare America for this November's election. And one of those recommendations, specifically number 4, contemplated the idea that there might be a gathering of the election law community of scholars to see and explore whether there could be any scholarly consensus developed around today's topic. The idea that there are ambiguities and pitfalls with respect to the legal rules and principles that might govern in the event that the presidential election becomes disputed. Particularly so if the dispute ends up being different from Bush versus Gore 20 years ago, and different in the sense of reaching all the way to Congress next January under the arcane procedures of the so-called Electoral Count Act, which may end up being very much part of our discussion today. So we here at Ohio State, who have been fortunate enough to have done scholarship on this topic, thought that we could help implement that type of recommendation. And so we see today's discussion as a preliminary step in implementing recommendation number 4 of that report. And we welcome input and feedback after today on the extent to which additional steps should be taken on that very specific recommendation. Before we begin, I just want to say that Steve and I are very mindful that today's date is the 50th anniversary of the shootings at Kent State University on campus here in Ohio. And although our conversation today discusses the present and the future, we are mindful of the fact that that national tragedy a half century ago will be on people's minds today, and we just want to recognize that point. Steve, is there anything else you'd like to add before you kick off our initial conversation?
I think we're ready to go, Ned. Thanks. It's really exciting to have this happening. We've been looking forward to it for a while. And again, sorry we can't do it in person, but we're so appreciative that you're engaging with us in this way. As you all know, we've structured the day around 3 time periods in the electoral process. The first time period being the approximately 6 weeks or so from when Election Day occurs to the day when the electors meet on December 14th. And that's what we're about to talk about now. But then later today, we'll have a session devoted to issues that might be of moment in the period between when the electors meet on December 14th and when Congress meets to count their votes on January 6th. And then our third session will include our day today when we'll think about issues that might still be of concern between when Congress has met on January 6th and Inauguration Day on January 20th. In each of those time periods, we have identified 3 hypothetical scenarios or created 3 hypothetical scenarios that we've shared with each of you ahead of time. And we will assume that you're essentially familiar with those hypotheticals rather than reviewing in detail now. But they are on the website. You can find them there. I wanted to refer to them, and for those of us who are attending and haven't had a chance to see them ahead of time, they're all there. As a set of background law, the most pieces of the federal law that governs these issues are also on our webpage, so everyone can refer to them there. But we're presuming that all of us in the round table are familiar with the background law as well as with those scenarios. So our first scenario, which just for summary purposes, we've called Philadelphians who experience delays receiving absentee ballots, is a scenario that is obviously ripped from the headlines, if you will. This is the kind of worry that we had been thinking about in not necessarily exactly this configuration before what happened in Wisconsin. But of course, after Wisconsin, it's now easy to see how this hypothetical could become reality for us. The way we've structured this first one is to imagine that in light of both the COVID challenges that could persist or recur shortly before the November election, and the fact that Pennsylvania for the first time this year has permitted any voter to request an absentee ballot they would mail in, that the election officials might be overwhelmed by demand. Have people requesting simply because they have that option now, coupled with or multiplied or compounded by the number of people doing it because of the COVID-19 challenge to voting in person, and that could overwhelm some jurisdictions, in particular the large cities. So our hypothetical assumes that Philadelphia has been unable to distribute the requested absentee ballots in a way that would allow the voters of Philadelphia to return them by the deadline, which under state law would be the close of on election day. And in that moment, in that circumstance, voters, some plaintiffs had asked the state court for relief, and the state court had allowed those voters to use what we call the federal write-in absentee ballot. This is a pre-existing downloadable ballot that is intended for military and overseas voters to be able to use in the event that they had not received their regular absentee ballot. So our hypothetical presumes now that the state court is allowing regular voters to use the same federal write-in absentee ballot and simply to sign and date it by election day, and then ordering election officials to count that ballot as long as it's received by 7 days after election day. That would be the 10th of November, the deadline that already exists in state law for the return of those same ballots from the military and overseas voters. In that circumstance, we then have postulated or hypothesized a federal court action in which the Republican Party has challenged the federal court, has challenged the state court order as inconsistent with cases like Roe v. Alabama, violative of the due process clause, by changing election law in the middle of the election. And in response to the request that the Republican Party has filed in federal court to disallow this state court remedy, the plaintiffs in the state court action have now joined the federal court case, arguing that the Equal Protection Clause requires that this remedy stand in order to protect their right to vote. So this sets up a conflict between the Equal Protection Clause and the Due Process Clause, and potentially also Section 2 of the Voting Rights Act. And so we've asked you all to think about how you, as a federal court judge, might resolve that question. Before we dive into that, I just wanted to mention one more dimension of this process today, which is that we are expecting most of our conversation will occur through the oral participation in the webinar. We have the potential to use the chat feature of the Zoom platform. We don't, at this point, have it active for the attendees who are observing. If at some point later on there's an opportunity for us to use the chat feature for attendees, we may, but that's not part of how we are structuring what we are now ready to do. So at this point, let me throw it open and just see who's ready to tackle this initial scenario for us. Who wants to get us started? All right, let me call on somebody for a minute. Josh, can I ask you to give us your initial reactions to the federal law issues here?
Hey, Steve, before you do, I just wanted to note that when the Chief Justice cold called Clarence Thomas today, he actually had some questions. So.
Oh, that's great. Thanks, Marty.
Well, we're not expecting our participants to be shy, so we're looking forward to a robust and lively discussion. But since Josh was flagged out, unless anybody else wants
Ned or Steve, this is Matt Masterson. I'm sorry, I'm going to be the guy that throws out just a technical detail around election administration on what the federal write-in absentee ballot is or is not. For those that don't know, the FWAB, or federal write-in absentee ballot, is not an actual ballot that's got candidates on it. It's in fact simply a form that someone can write in their selections on and submit, right? And so that's only important from both a voter education standpoint on who's eligible. And so typically when a military or overseas voter has to use the FWAB, all state or local election websites have to post who the eligible candidates they could vote for so that people know who they could write in because it's not on the actual FWAB. Now, there are some FWAB tools that allow you to select candidates. Certain nonprofits offer that, but generally speaking, the FWAB is literally just someone writing in names on a line. That also leads to state or local officials having to transcribe those ballots into something that could be counted. And so just not to get into the nitty-gritty details of election admin, but just for the context.
Thanks, Matt.
That's really helpful. And I guess I just want to underscore the point that I think the key issue for purposes of this first scenario is conceptually the same thing that happened in Wisconsin. Namely, you've got a state statute that says one thing, that ballots must be delivered by 8 p.m. on election day, absentee ballots. But then something happens in real time that seems to be like an emergency that wants there to be pressure to deviate from the statute. In Wisconsin, it was voters not getting absentee ballots that they had requested on time, and they had done everything right. And so they were looking to be disenfranchised if they couldn't vote by absentee. The federal district court created a remedy that the US Supreme Court had to modify in part. And the question is, what if that gets replicated in November? Could be Wisconsin again, could be Michigan, or as our scenario says, in Philadelphia. And there's litigation around this competition between, hey, the rules as written say all absentee ballots must arrive on 8 p.m. But if Philadelphia is failing to give absentee ballots to their voters, what happens? The FOB, the federal substitute that's available only to military and overseas voters, is just an analogy. And the question is whether what if a court ordered something equivalent? Would that be so much of a deviation from state law that would force the federal judiciary to intervene in the way that the majority of the US Supreme Court did in the Wisconsin case, and said, no, that kind of judicial remedy is too much of a deviation from the state statute. So that's the kind of scenario that I think we have in mind as potentially affecting the outcome of the entire presidential election. And is there anything that we collectively can say usefully about that general problem in advance, so it doesn't just become a partisan food fight?
So I know I called on Josh, but I now have Liza and Paul and Rick eager to participate. So Josh, you're welcome to interject, but let me ask Liza what she's thinking.
My point was just that I think the Supreme Court's intervention in the Wisconsin scenario is not necessarily dispositive of what we would see here, because there were a couple of factors in the Supreme Court's decision that seem very important to the court, at least in the per curiam decision, that are not the case, that would not be the case in this hypothetical. One of which was the court seemed extremely moved by the fact that the plaintiffs in that case had not actually requested the full relief that the district court granted in their preliminary injunction briefs. Now, the dissent noted that they had in fact requested that relief in the hearing, but that apparently was not enough, and the court felt that it was just going too far to make such a drastic change, right on the eve of the election, when the plaintiffs hadn't even asked for it, essentially. And that presumably would not be the case here. And the other factor that seems quite significantly different is that in the scenario we're talking about here today, people would have to postmark their, or would have to sign and date their ballots by November 3rd. Whereas in the Wisconsin case, the district court had actually extended beyond Election Day the time that the ballots could actually be cast and filled out. And the reason why that's significant is because in order to prevent ballots cast on Election Day and the results of those ballots from affecting how people voted afterwards, the court in the Wisconsin case actually had to sort of put a gag order on anything coming out of the electoral results for several days after the actual election day. And the court said that it wouldn't work. It wouldn't be practicable. Things would come out and that could change the outcome of the vote. That presumably wouldn't be the case here because you wouldn't have that need for a gag order after November 3rd. So there are some pretty significant differences in the Wisconsin case from the scenario here, and some pretty powerful, I think, due process and equal protection arguments for why the court might order that kind of remedy.
Thanks, Liza. Let me turn to Paul.
I agree with Liza that maybe the main sort of lesson from the Wisconsin case is that while you can extend the time to get your absentee ballot into the state in the face of exigent circumstances, it's a much more serious interference with normal operations to extend the time when the ballot has to be mailed past Election Day. And that's what the court changed. It left in place the ability to have the ballot mailed on Election Day and received days afterwards. And as I read the hypothetical, it seems to conform to the Wisconsin system that was left in place after the Supreme Court ruling, but with one potential exception. The hypothetical has changed to say that the ballot has to be signed and dated by Election Day. There's no reference to postmarking. And it would seem to me that a big problem here is that anybody could print this ballot and sign and date it days after the election, as long as it was mailed in time to get in by the 10th, and it's just local mail. So there is at least the way it's phrased, apparent problem of safeguarding against post-election day packing the ballot box.
Thanks, Paul. And you're right, there is that difference about the postmarking requirement. The hypothetical imagines the relief is consistent with the way the federal write-in absentee ballot is used, which does not require a postmark. And in part, that's a reflection of the reality that postmarks are not necessarily a regular part of the way mail is processed. And one of the things, at least I think it's worth a brief reflection on, is contrary to a lot of the discussion in the popular media that has been occurring even as recently as today, coming out of the Wisconsin election, that suggests it's a failure on the part of the post office when a piece of mail does not have a postmark. Contrary to that popular perception, my understanding is there is no necessary requirement that every piece of mail have a postmark. The postmark exists primarily and originally for the purpose of the Postal Service's ability to know that a piece of postage has been used, not to evidence proof of mailing. And that today there are lots of alternative ways that postage can be canceled, and that postmarking is not a regular part of the process. So where does that leave us? I won't answer that question, and I don't mean to make that to be the subject of our discussion right now, but it is a wrinkle in this hypothetical. So Rick Pildes, you had some other thoughts. Go ahead.
Yeah, so as I understand the hypothetical, it's a different and even messier situation than the Wisconsin litigation, because in the Wisconsin situation, all the litigation was taking place in the federal court. And so the question there was, what does the federal constitution require in terms of protecting the right to vote? What are the limits on the remedial powers of federal courts? The situation you're posing, which is easy to envision in the American context, is dueling federal and state court litigation over these issues. And that's one of the unfortunate features of the way our system is structured, that in every one of these contexts involving federal elections in particular, particularly the presidency, it's easy to imagine that we're going to have plaintiffs in the state court and plaintiffs in the federal court, and on top of all the other uncertainties, it's the relationship of the two systems that you're raising in this hypothetical. As you mentioned, there is this kind of federal constitutional overlay to what state courts do when they're dealing with the running of elections, including national elections. And that is that the federal courts, though they mostly leave these matters to state courts to resolve, do have some power to decide that what the state courts have done violates the federal constitution. And so the question is, when does that get triggered? And there are only, as far as I know, two instances in which the federal courts have held that state law was so misapplied by the state courts that what the state courts did violated the Constitution and had to be thrown out. But I will say that your hypothetical does kind of raise the context in which this could be a live issue, because typically, and in those two cases, state courts are purporting to interpret state law. And then the question is their interpretation so out of bounds that they have essentially changed state law after the election, after it started? Your hypothetical is a situation in which there's no question that that's what state courts are doing. They are changing state law in this emergency context. They're saying it's the appropriate thing to do under the state constitution or state statutes. But by definition, your situation is one in which the state courts are changing state election law. And so that opens up, for sure, the kinds of issues that you're raising about, will the federal courts say, you've exceeded your power under the Constitution, this is a fundamentally unfair election, now that you're changing these rules after the rules were set up for the running of the election. And so I just want to point out, even though it's a mess and very complex, how different the situation that you're posing here is compared to what is in some sense the much easier situation in the emergency context that we faced in Wisconsin.
Well, you're exactly right, Rick, which is sort of why we created the hypothetical that way, right? In other words, to put pressure on the point that if the Pennsylvania Supreme Court is basically clearly deviating from the text of its statute, but thinks it's got a good reason to do so to protect voters from wrongful disenfranchisement, should the federal judiciary let that go and say that the state Supreme Court's entitled to protect its voters in that way, either by appealing to the state constitution or what have you, but it is remediating the situation in a way that deviates from the text of the state statute. Or instead, should the federal court intervene and say, no, 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 you can't make that much of a change in state law? I mean, I think you put your finger on the key point. I see Justin next.
Well, and so after Justin, I also have Michael Morley, who alerted me without raising his hand on the Zoom. So we'll go Justin, Michael, then Liza.
So I'll make this brief because I want to hear what Michael has to say. I'll agree with Rick that you all have constructed the hypothetical extremely well. So thank you for challenging us all today.
That's the easy part.
Yeah, that is the easy part. I'll also, by the way, thank you for convening all of this. It's magnificent to see everybody at this time. I do want to push back a little bit on the notion that the state court here would have changed the rules. I take as a given that the statute exists, and it's clear that, as Ned said, they've deviated from the statute. But all of those state statutes come with an underlie of the state constitution and the federal constitution. And to the extent that a state court is applying reasonably, as we say, as Rick said, within bounds, state constitutional law or federal constitutional law, I don't think the state court is changing the rules at all, even if it deviates from the text of a statute that can't be constitutionally applied in a given situation. That's a different framing, but I think it's really important. If there were a clearly unconstitutional state statute that were nevertheless passed and signed by the governor, I take as a given that we would not think the election could proceed under those rules based on state constitutional law or federal constitutional law, and that a court recognizing as much wouldn't be changing the rules, would just be upholding them. And I think the situation you've set up here is, in a way, exactly that. In part because, although I don't think that this is the appropriate principle to guide us, the courts seem to repeatedly think, and I know Ned has written about this quite a bit, that fault is something the courts take extremely seriously in viewing when statutes can be used to disenfranchise. And that particularly, at least when the state has deprived the voters of the opportunity to cast a meaningful ballot through no fault of their own. I think it should apply far more than these circumstances, but at least in those circumstances, the Constitution tries to provide a remedy wherever possible. And so if that fault principle that Ned's identified in a bunch of his own writing, that Rick's identified in a bunch of his own writing, Rick Hassan, if that fault principle is, in fact, as I think it is, a guide to what due process means, I don't think the state court giving meaning to that due process principle is changing the rules at all.
Can I ask a question, clarifying question? Is the scenario is that the lawsuit in state court premised on state law, state constitutional law, or federal constitutional law, or both?
I think we can play around with that. I think we should initially think that the Pennsylvania Supreme Court is relying on the Pennsylvania Constitution as superseding the explicit text of the statute. And first think of it that way. You can also imagine the Pennsylvania Supreme Court invoking, federal constitutional principles. But I know that Josh actually would like to jump the queue, if okay, and then before Michael steps in, and I think we should at least have some flexibility. So,
Yeah.
So Josh, go ahead.
Thanks, Ned, and thanks to you and Steve and everyone at OSU for organizing this. And I guess I realized I was on call earlier but didn't hear it, so I plead ignorance in my failure to respond to the professor's Socratic method earlier. I want to follow up on Justin's point explicitly in terms of the state constitutional play that at play here, something as you all know, I've written about a bunch. And the Pennsylvania Constitution actually has, I think, precedent directly on point in the partisan gerrymandering case, where it used its free and equal clause to more robustly protect the voting rights of Pennsylvania citizens. And I think that would come into play here, to say that it's not, in a situation where the Pennsylvania courts are so-called changing state law, but interpreting the current election process consistently with the state constitution, which does go beyond the Equal Protection Clause in terms of its protection of the individual right to vote. Which actually brings me to a sort of first principles question for consideration, which is, should there be just an overall or overarching principle of allowing people to vote? I'm thinking about, Rick Hasen's democracy canon, or just sort of a first principle that in construing any of these hypotheticals, shouldn't there be a thumb on the scale of participation during this sort of emergency situation? Now, I have a sense that Michael Morley will have a good response to that, but I guess I just want to throw out there the idea that, especially consistent with state constitutions and what they say as being sort of part of this conversation, shouldn't the thumb be on the scale of allowing people to vote so long as it's consistent with equality principles?
So this is probably a good time to turn to Michael.
Okay, and I'd also like to join in everyone's thanks to you guys for organizing this amazing discussion. I think that we're going to have a lot of good coming out of it. A few quick points that I'd wanted to throw in there in response to what we've been talking about so far. The first thing is, I think that your scenario, that in approaching a lot of your scenarios, in particular this one, it's important to distinguish between the merits question of, has some sort of, in particular, constitutional right been violated, and then the remedial issue of, if so, what is the proper remedy? And so, as Josh suggested, certainly to the extent that there are state constitutional claims being raised, state Supreme Courts are free to go beyond federal precedent and provide different types of tests for construing their constitutional provisions. They're able to go beyond what a federal court would do in a federal constitutional case. To the extent that state courts construe their state constitutions in lockstep with the federal constitution, or even if they do have independent tests, they wind up being substantively similar to federal standards. On the merits issue, it wasn't entirely clear to me whether there actually was a due process claim or an equal protection claim here that would warrant certainly federal constitutional relief or state constitutional relief to the extent that it was similar to federal standards. Right? There's plenty of federal circuit court cases saying that garden variety irregularities, that the ordinary types of mishaps and problems that occur in the course of an election, including violations of state law that ordinarily might occur during the course of an election, don't necessarily rise to the level of due process violations. And one coda to that line of doctrine, which is something that I haven't even been able to reconcile myself, even when they're potentially dispositive, that there are circuit court rulings saying that even where you have a potentially dispositive number of ballots at stake, that doesn't necessarily rise to a due process violation. And in viewing things in equal protection terms, I agree, it comes back to mens rea. But again, right, there are lots of equal protection cases in this context that are looking to the mens rea of the election officials and the government officials. And in the absence of intentional conduct, intentionally discriminatory conduct, it's not immediately clear that this type of mishap, particularly if it's one that was caused by the Postal Service as opposed to state election officials, would necessarily give rise to a constitutional violation. A second point that I had wanted to flag, which I was very excited to see your scenario get in there, deals with the scope of the relief, which is something that we haven't talked about yet, right? Under the facts of the hypothetical, the problems were limited to one particular city, and yet the state court decided to grant relief throughout the state. And so on the one hand, depending on who the plaintiffs were in that case, you see a variation on the nationwide injunctions debate that we've been having, right? The question of, can the relief only be given to the particular plaintiffs before the court, or instead can the court issue what I call a defendant-oriented injunction, going beyond that and giving relief to all people throughout the relevant jurisdiction, right, including third-party non-litigants who live elsewhere within the state. And you also see tension here between, on the one hand, even putting aside the state law equivalent of the nationwide injunctions problem, you see tension on the one hand between equal protection principles, right, wanting to give all voters within the jurisdiction equal opportunity to vote, while on the other hand, recognizing that there's only certain people who've been proved, right, there's only a certain jurisdiction that was proved to have this burden to voting, that had this delay, and so it could actually wind up being unfair in a different way to extend extra voting opportunities throughout the entire state, given that the vast majority of people who would be getting the benefit of that didn't face any delays, didn't face any irregularities or burdens. And so that's going to be, I think, a recurring issue whenever we're talking about relief for unexpected emergencies, relief for unexpected election-related crises. How broadly do you confer, even if relief is appropriate, how broadly do you confer it just to the affected people, or do you confer it throughout the entire state? The one final quick point I had wanted to throw in there, specifically on the FWAB issue, there are a few complications, I think, to the use of the FWAB, which again is essentially a blank piece of paper that you're letting voters send in. The first is that federal law has special rules for counting federal write-in absentee ballots. So you can just write the word Democrat or write the word Republican, and that's supposed to be able to count as a vote for all of the party members from that particular party. There are rules that say you have to count it even if it's misspelled, where a lot of states, not Alaska, but a lot of states have rules that require you to actually write out your write-in ballots correctly, that it doesn't count if it's misspelled. And then finally, many states actually have their own state write-in absentee ballots, their own state analogs to the FWAB. And so to the extent that states have already, and Pennsylvania, I quickly looked, Pennsylvania is not among them, but for states that actually have a state write-in absentee ballot, it seems problematic for a state court under state law to say, we're going to let you use this type of document that the legislature has already limited to particular circumstances or to particular voters.
Yep. Thanks, Michael. Let me turn next to Liza.
All right, just unmuting. Yeah, wow, that was really interesting. And I feel my comments are unrelated, which feels strange after all of that food for thought. But I was just thinking about the issue of whether or not the rules have been changed in the middle of the game and the effect of that. And I think regardless of whether or not you see an intervention in a situation where the strict application of state law would be unconstitutional, regardless of whether you see that as changing state law, it is certainly changing the process for voting, fairly dramatically, sort of in the middle of the game. But I think that does not necessarily by itself dispense of the question of whether there's been a due process violation by virtue of that remedy, which is what the Republican Party would be arguing in federal court. And there are a lot of considerations there, but I would point to one consideration which the 11th Circuit noted in the Roe versus Alabama case, which is whether or not there was some kind of detrimental reliance on what the status quo was before the change, whether people would have changed their behavior if they knew this was coming, essentially. And in the Roe case, essentially the question was whether a decision to actually count ballots that did not comply with state law because they were sent without absentee ballots that were not notarized, not signed with two witnesses, and therefore were not compliant, would nonetheless be counted. And the idea was if they decided to count those after the fact, then a lot of people who might have gone ahead and submitted absentee ballots if they knew they could do it without the hassle of finding a notary and getting two witnesses, a lot of those people probably would have voted but didn't. And so it changes the result and it dilutes votes, or that's the argument as a result. It's hard to see in this case how the change, I think there is a change here in the middle of the game, how that would, how anyone would have behaved differently if they knew that was coming, because you have to have, in order to take advantage of this remedy, you have to have requested the ballot in time to have received it on November 3rd if things were proceeding in the ordinary course. And so it's missing that element. That's not to say that there is no due process issue here. I'm just saying that it's something to consider in the analysis.
Yeah, good point. I see Rick Hasson next in the queue.
Hi, and let me add my thanks to everyone at Ohio State for putting this together. I think it's very important for us to be having this discussion now rather than in December, as the election is still going, potentially. A kind of a practical minor point and then a larger meta point. The smaller point is that I would hope that if the state court is going to order relief like this, it's going to do what some courts have done in the past, which is bring in election officials and ask them if this is actually doable and if these ballots can actually be counted. I'm not confident that Philadelphia election officials would be able to handle thousands of these ballots and be able to process them in a way that wouldn't raise yet another lawsuit about due process concerns about the actual counting of those ballots. So I think that's something we need to keep in mind when we're thinking about any kind of relief that a court may order. We saw it in the Wisconsin case where the U.S. Supreme Court went to the postmark, and that turned out to create a whole bunch of new issues because there was not consistency in how the local election boards dealt with non-postmarked ballots. You have to think a few steps down the line. The larger meta point is that as I was listening to Rick, Josh, Justin, and Michael talking about some of these due process issues, I was having kind of nightmare flashbacks to Bush versus Gore, actually to Bush versus Palm Beach County Canvassing Board, the first case, and raising the question under Article 2, whether reliance on a state constitution can be a legitimate way of changing rules for presidential elections, even when or without the state legislature affirmatively agreeing to those changes. And I think so the meta point is this: if that question arose, I expect we would see exactly the same ideological and partisan division between conservatives and liberals, between Republican appointed justices and liberal appointed justices should it get to the Supreme Court over that question. And it shows me I don't think we've made any progress in 20 years in terms of how we're thinking about these questions and how we might get a partisan divide on the courts, because you can kind of hear the arguments being made here, the echoes of exactly what we heard in Bush versus Gore. Competing state and federal courts, competing due process and equal protection issues on the one hand with Article 2 issues on the other. And so I think it's even more of a mess than we've been describing it so far.
Well, that's sobering, but let's pause on that. Paul, I see next.
Hi, yeah. I just thought I'd raise a procedural issue. It seems to me there's a serious question whether the federal court in this context would or should take the case and review the constitutionality of the remedy that the state court has imposed, particularly assuming, as I do, that the Voting Rights Act and federal constitutional arguments are going to be at least part of the state court analysis as well as the state constitution. There's all sorts of doctrines, abstention doctrines, Rooker-Feldman and things, that say a federal district court can't review the judgment of a state district trial court, but that there's a proper way to appeal it. And I think that that's why I think this likely would not play out this way, but maybe I'm wrong.
Just to jump in real quick on that, does it help to vary the scenario along the lines that Rick just suggested of where the U.S. Supreme Court might grant cert straight off of the Pennsylvania Supreme Court's decision? That would make it look more like the Palm Beach Canvassing Board case, wouldn't it?
Yeah, but much more. That's the proper way to have it get reviewed, not by going to a federal trial court.
Franita.
Hello, everyone. Let me join the chorus of thanks to Ned and Steve and others for putting this on. I actually have a question. How are we using the word ordinary? Because there's a lot of discussion about what ordinarily happens when mistakes are made by the state or by the post office or whoever it may be. And one of the reasons why I'm confused is because in RNC versus DNC, the Supreme Court even uses the word ordinary, right? When they talk about the fact that voters had not received their absentee ballots, they say in an ordinary election, voters, that sort of thing happens, right? But there's nothing ordinary about this situation, right? This is a situation in which we're looking at most voting probably occurring by mail. And so it seems to me that would warrant some consideration of what the rules should be. and whether or not there should be an alternative framework in how we think through these issues. Because, you know, trying to sort of shove this into the framework of ordinary just seems odd to me, because there's nothing ordinary about it. And even more importantly, the Supreme Court has been responsive to extraordinary circumstances, right? That's Bush versus Gore, right? We're not deferring to general federalism principles because this is a presidential election. This is an extraordinary situation. And so why treat this as ordinary when we're in the middle of a once in a century pandemic? So that's my first question. My second point, I guess, less of a question, is about the scope of the remedy that Michael raised. I think it raises a really interesting question. And maybe it is a question that I'm not sure of the answer to. It seems to me that in the hypothetical, the remedy ordered by the state court, it struck me as okay because the voters seem similarly situated, right? So the state court ordered a remedy for voters who had not received their absentee ballots, which they are similarly situated to the people who actually brought the litigation. But on the flip side, is there some concern that we have to think about the fact that local election boards are possible non-parties who are being bound to this decision in a way that reconciles against that, similar to the concerns that Michael raised? So yes, these plaintiffs are similarly situated. They suffered the same harm. They've suffered the same harm in a way that's not true if you think about Bush versus Gore and the fact that the Florida Supreme Court ordered a statewide remedy with undervotes, right? Because there were not uniform counting standards. But here you don't really have that problem. These voters are similarly situated. But on the other hand, we still have this problem where, you know, local entities are the ones counting these votes. And so are we concerned about binding them to this decision in a way that might counsel against this particular type of remedy?
Yeah, those are good questions. And before I go next to the queue, Fernita, can I just follow up with you real quick on the first point that you raised about what counts as ordinary? I mean, I take it that no matter what in November, we're going to have an unusual election because of the pandemic. But is it possible that courts will think that officials will have had 6 months to prepare, unlike Wisconsin, where the emergency happened very fast, maybe not as fast as it happened for us in Ohio back on March 17th, but nonetheless, you know, voting in the April Wisconsin election was right when the pandemic was at its peak. Is there going to be more of a sense in November that the relative difference between absentee voting versus in-person voting, if not like a regular election, doesn't justify the kind of extraordinary judicial relief that this scenario posits the Pennsylvania Supreme Court is adopting? And if that's true, would then the federal court be more willing to second guess any deviation from state statute that the Pennsylvania Supreme Court does, because it would say that there's less of an emergency justification for that kind of deviation?
For me, it depends on what we care about, right? We know that state election officials are only going to be able to prepare so much because they're underfunded. And so to the extent that we recognize the practical realities on the ground, why not defer to state courts' interpretation of state law and not treat it, sort of to use Justin's framing, right? And not treat it as a post-election change, and instead sort of view it as within the court's power to protect the right to vote. So to me, that's a value judgment, because we already know that there will be problems because state election officials are not being funded enough. So I don't know. I don't pretend to know the answer, but I do think we're choosing between the equities here, and you know, if the right to vote is something that we care about, I just don't understand why we wouldn't err on the side of that.
Yeah, no, fair enough. But also to Rick Hassen's point about discussing this now rather than in November, you know, I think there's two things that we could usefully do today as a group of scholars. One is answer the normative question that you're putting on the table for us, saying, you know, do we collectively think that we agree amongst ourselves as a right answer, correct answer to these 14th Amendment questions involving due process, equal protection in scenarios like this hypothetical? You know, I'm agnostic as to what we think. I want to hear more from everybody about that. And then secondly, you know, what's the relationship of our views to our prediction of how the US Supreme Court, if it got the same question, would decide. I mean, they obviously split 5-4 in the heat of the moment in Wisconsin. Can we think that they might do better next time in a scenario like this and actually achieve some sense of, cross ideology unanimity on the right answer to how to handle these equal protection due process sets of issues?
They won't do better, but let's not let that stifle our conversation.
All right, fair point. Larry, you're up.
Thanks, and echoing others and thanking Ned and this group for convening this discussion. What I want to say really builds on Fernita's point and goes back also to Michael's distinction earlier between sort of garden variety election irregularities and what might be at issue here. And my reaction to the hypo is that there are some really intriguing ambiguities in how the hypo is written, and sort of the contours of the hypo might matter a lot. So, for example, the reference to extraordinarily high demand for vote by mail as a result of COVID-19, could be high demand because we've all internalized some ideas about social distancing, or could be a shorter term surge in demand because there's a second or third wave outbreak and expectations about the availability of in-person voting might be shifting in real time very quickly. So that struck me as sort of one important ambiguity. The other sort of the reference to problems with the Postal Service is that at the margins, or is the Postal Service suffering a financial collapse, and is the president tweeting about the appropriateness of not bailing out the Postal Service because he wants to prevent all the fraudulent vote by mail? It seems to me like those facts could matter both from the perspective of conceptualizing the potential due process problems here, and also could have relevance for thinking about what is the appropriate application of the Purcell principle, which again might be different than what do the 5 justices who were in the majority in DNC versus RNC think. But the extent to which these dynamics are driven really by exigencies that are happening in real time, as opposed to slower burn problems that might feel more like garden variety imperfections in the administration of the election.
Thanks, Larry. I've got Lawrence and then Sam.
Actually, I think my comment in some ways has been addressed by Ned. I was just, and when some of the people like Rick were talking about the overtones of Bush v. Gore, when Ned was asking about whether the federal court would be willing to second guess the state court, it sounded like a lot of what we were doing at that point was engaging kind of a predictive exercise. And it just struck me that maybe more of what we should be doing is, Ned mentioned that we could be doing both the predictive and the normative. I guess my own feeling would be, it would be more useful to focus on the normative rather than the predictive. And it seems like another thing that when we're focusing on the normative rather than the predictive, and maybe this goes back to some of the things that Fernita was talking about as well, is that there is, of course, the elephant in the room, and it is this, and I guess Larry just mentioned this as well, when you're having Trump tweeting these things out, and it seems like that's a very important thing to bear in mind. So it seems like the best thing that we could do today would be come to some kind of normative consensus, if that's possible, rather than make kind of predictions about what's going to be happening.
Yeah, thanks, Lawrence. And I'll just reiterate that part of the way we sent these scenarios out was with an invitation to ask each of you to put yourself in the position of the decision maker, the judge, not the academic spinning out the pros and cons on each side, but how you might actually think it should be resolved. And Lawrence, to your second observation there about sort of the real world politics of all this, in a minute or a few minutes, maybe we'll turn to the second scenario, which is of course driven principally by just that dimension of the current realities. But let me let Sam keep talking about this scenario, and then Kate. So go ahead, Sam.
Okay, leaving aside the question of whether Article 2 prohibits a change at this particular moment, and the McPherson versus Blacker question. The difficulty is that most of these general principles of state constitutional law, federal constitutional law, are presented at a very high level of abstraction, which means that the federal courts, which have ultimately the All Writs Act power, are in the difficult position of having to determine whether state courts have changed state law so substantively as to trigger the kind of Roe v. Alabama due process or equal protection concerns. The way this plays out, I think an example comes from 2008 in Ohio on Election Day, where you had the Democratic candidate running to state court to get some kind of relief and a declaration as to what the state law was with regard to a number of potentially contested, this was even before they were contested, election results on election practices on Election Day. And you had the Republicans going into federal court at 8 in the morning claiming fundamental due process claims. And really it was a battle over jurisdictional authority between the federal and state courts. And on the federal side, the litigation went up and down to the Sixth Circuit twice on Election Day before it was resolved. And we could come up with a principle that says that clear departures trigger Roe versus Alabama, trigger the Bush v. Gore type concerns. The difficulty in practice is that what is a clear departure under circumstances, particularly as the hypothetical says, of something like a pandemic, which could flare up immediately on the eve of the election in much the way that Hurricane Sandy disrupted the election day processes in New York and New Jersey in 2012. I think that it's going to be a turf war between federal and state courts, and I fear that there are first to file principles. Paul mentioned the Rooker-Feldman potential conflicts that happen. It's actually not quite as so clean as Rooker-Feldman, and those are words that are rarely said together in a sentence, but it's not so clean as Rooker-Feldman because what you tend to have is both federal and state court litigation going on simultaneously with no clear authority as to even first file.
Thanks, Sam. Go ahead, Kate.
Yeah, so I think those are all obviously really important kind of jurisdictional points. I was going to make an additional point that is more sort of a pragmatic timing one, which I'm not sure that the scenario here is totally clear about when the initial lawsuit is filed in state court. But it strikes me that if we are starting to shift to kind of to try to get to some provisional answers to the question that is posed at the end of the scenario, should the federal court grant or deny the injunction, it seems as though maybe under existing doctrine, it matters a lot, you know, how close we are to the election. And I think that, you know, RNC versus DNC arguably, you know, I think 3 or 4 times uses the phrase eve of an election, within days of an election. And that district court PI, I think, was April 2nd, 7th Circuit, April 3rd, Supreme Court the 6th, and the election was the 7th. So, I mean, Rick, I think Pildes early on sort of said something about, and the scenario does too, changing the rules after ballots have been cast. But it seems to me there has to be some kind of more nuanced analysis than just, it can't just be binary. If it's, you know, if we're a day into the absentee or early voting period, it can't be that all, you know, all courts, state and federal, are disabled from remedying potential violations, where I think the closer you get to the election, obviously, right, that's Purcell, that's not new, but I do think it sort of takes on somewhat maybe new significance after RNC versus DNC. But in terms of the scenario, I mean, the answer may be that if we're still a few weeks out from the election and you can get affidavits from election officials that sort of underscore a lot of the problems that the scenario identifies, no, you know, a federal court should, whether we're talking about Paul's variation of the, you know, kind of jurisdictional precepts of this scenario, or it is a federal court challenge to the state court ruling, it seems as though if it's a couple of weeks out from an election and it's remedying these very clearly identified deficiencies, there's a strong argument and there's seeds in the doctrine already that kind of remedial step, whether it, is statewide or sort of more locally focused, is perfectly appropriate and should not be stymied by this kind of federal judicial intervention.
Josh.
Following up directly on Kate's point there, it's not clear to me if the scenario is envisioning an election contest under Pennsylvania law, or sort of I don't want to say garden variety lawsuit, but if it's an election contest, then the procedure changes. In Pennsylvania, for presidential electors, election contests go to a special 2-judge court. And it's sort of weird. It's the 2-judge court of the 2 nearest president judges, is what the statute says. But that could at least complicate the consideration of this. I'm not sure what that does in terms of the substance, but I think the procedure is also important.
So it's noon now, and we've got some other scenarios I'd like to at least put on the table, and then we can decide where we want to take the conversation. I want to ask all of the panelists this question and try to get, I'm not going to hold you to anything, but I'd love a show of hands raised if you agree that what I'm about to propose is a good idea, and keep your hands down if you think it's a bad idea. And the question is really a feasibility one that relates to the point that Fernita and Lawrence and others have been saying about, focusing on the normative question and whether we can get some kind of agreement. My take of the tenor of the conversation so far is that there's enough variation or uncertainty in the hypo of the scenario, even though it was lengthy and had some specificity in it, that depending upon how particular questions about it were answered might make a difference to some people about due process or equal protection. Again, the timing of the dates or the how severe the pandemic was at the moment. But so my feasibility question to all of you is, if we tried to refine the hypo, maybe made it where it was going straight from the Pennsylvania Supreme Court up to the US Supreme Court on an emergency stay, more like Wisconsin in that respect, and less involving Rooker-Feldman or anything like that, would it be useful to circulate a new version of it with the hope that those of us in this community would be willing to say how we thought the fact pattern should be answered as best to our own ability from our own normative frame? Would we agree with the Republicans seeking to overturn what the Pennsylvania Supreme Court, and that was the right answer under federal law, or would we reject that claim? Is that something that we think that we could get a consensus on, again, well in advance of November itself, or is that just too difficult? So raise your hand if you think that trying to get consensus on that is a worthwhile thing to do, at least tentatively, and then don't raise your hand if you think that's just a too difficult enterprise. I'd just be curious as to what all of you think. So I'm seeing some hands raised, a significant number of hands raised, and interestingly, a significant number of hands not raised, more not raised than raised. So,
Ned, who would be the audience for this?
Great. The public, I think, this goes back to Rick Hassen's report. The goal here, as I see it, would be, the big fear is that we're going to get severe partisan divide on any of these issues in real time if a dispute materializes. And Wisconsin is evidence to that, right? Both the Wisconsin Supreme Court and the US Supreme Court divided over the legal issues presented to both bodies in divisions that looked both partisan and ideological. And many of us thought it was kind of ugly that the judiciary was divided that way, given the necessity, to run elections, for the sake of the system as a whole. So I take it that the primary goal for convening an event like today is to see whether or not there are transpartisan or cross-partisan consensus from a scholarly perspective on these equal protection due process issues. And Sam's point was that that some things are stated at such a level of generality as not to be useful. So that's why we create scenarios and hypos to see whether, if this is what the facts look like, can we take due process and equal protection and actually say something useful about a scenario like this and identify a correct answer if, God forbid, a Philadelphia scenario materialized much like this hypothetical. So the audience would be the public, just to know that election law scholars have thought about this and believe that the law has some impartiality, some nonpartisanship to it, even given the vagueness of due process and equal protection and the uncertainty of precedents like Bush versus Gore and Roe versus Alabama. So that, that's the goal, I think. I'd love to hear more from all of you about the value of that goal, but I also do want to turn to the second scenario sometime soon. But before we do that, any responses on just whether seeking consensus is a worthwhile goal?
I just weigh in and say that even if the way in which Ned framed up the particular question right now has not generated majority support among our group, I would invite all of us to keep thinking throughout the rest of today about whether there are alternative ways that could productively operationalize the kind of thing that Rick Hassen's report was calling for in its fourth point, after today. What else might our community do to continue to provide some helpful guidance in the event of problems like the ones we're talking about today?
Marty, do you still have your hand up?
I do. I mean, I find this a little an interesting idea because, as many of you know, over the last few weeks, I think many of you would agree with me that many of these problems are only ever going to be solved if there is national legislation, amending the statute that we have in front of us, 3 U.S.C. 15 and the like. And dealing with as many of these problems at whatever level of generality, Sam, that Congress could do. And every time I suggest anything like that, the consensus response is, Lederman, this is absurd. Of course, Congress is never going to write a statute. The idea that we're going to convince John Roberts of the Wisconsin Supreme Court to act differently because we have a consensus of academics strikes me as even more pie in the sky than coming up with a proposal for Congress.
Yeah, fair point. Adal, I see your hands up.
Yeah, and to build on that, the issue is that even if you could come up with a consensus, getting people to buy into the consensus is just the first step. They essentially then have to take a pledge that they're going to stick to that no matter which way it manifests in terms of their political, the way it plays out, in terms of who would benefit and who would lose from abiding by the consensus. That would probably be difficult for practitioners and academics. It would be impossible for the political players.
Well, this is important, and I want to reflect on it. It is probably a point that transcends, multiple scenarios. Lawrence, I see your hands up, so let me go to you.
Again, it's just a very small point, but it seems a little bit self-contradictory to say, well, should we engage in some kind of predictive work, or should we be engaged in some kind of normative exercise? And then to answer that question by saying, well, predictively, the normative exercise isn't going to have the effect that we necessarily want. That seems like a kind of a self-defeating rationale. It seems like whether we can try to work for some kind of consensus should be evaluated separately from the question as to whether that normative consensus would have any kind of predictively helpful outcome.
Yeah, my own sense on this, for what it's worth, is, one possibility is simply to, kind of ignore this and just pray like it. Everybody knows the election administrator's prayer, which is pray to God that the election is not close and therefore it can't be disputed. But that, I hate to say, is like praying that the pandemic won't arrive on our shores. And so you know, there may be absolutely nothing we can do as an election law system, you know, to better inoculate the strength of our voting process and vote counting process to a Bush versus Gore kind of dispute. And we're just, you know, stuck with it unfolding in real time, as ugly as it may be, because advanced preparation is impossible. I guess before I reach that conclusion, I'd like for us collectively to consider, in this brainstorming way, all possible advanced planning ideas that might have some utility, whether they're thinking about Congress the way Marty was, whether they're thinking about courts, anything outside the box. Because, you know, I think if another Bush versus Gore arises, or something even worse, it's not going to be good for the country. So, you know, I hate at that moment to think, oh, if only we had thought ahead of time about ways to try to ameliorate the problem, or at least reduce the degree to which it became a partisan food fight. So anyway, I want to keep that in the back of my mind, and maybe our collective minds, as we continue to work through the various scenarios and issues. Rebecca.
Yeah, so I'm sort of frustrated with myself for not raising my hand when you asked whether we could come to a consensus, because I feel like that's a worthy goal and something that we should be, you know, trying to think about ways that we can put something on the table that's useful in the lead up to November. But I actually think that the discussion so far has actually been quite useful, in the sense that many of the comments have raised questions about wanting to know more about, you know, several variables that we've been discussing. So for example, how close to the election are we? Is the problem the post office? You know, various ambiguities that aren't resolved by the hypothetical as you presented it. And it strikes me that it would be interesting to, when those kinds of variables are raised, to perhaps come to a consensus about, if they fall this way, you know, we might agree that this outcome would be most appropriate, and kind of play a little bit more with those variables, rather than kind of an up or down vote. And I think that might help us sort of identify what we as a group care about, what sort of matters given the variables that people suggest.
Yeah, good. Lisa.
Yeah, thanks. So one thing that I wanted to say is that in terms of thinking about a consensus, for some of us, the answer to the question actually may not be an answer on the merits, but it rather may be an answer as to who gets to make that determination. So, and as a related matter, at least for someone like me, you know, I might have my views on the merits of how a certain hypothetical should play out legally. But then once something like the US Supreme Court weighs in on it, whether or not I agree with the way the Supreme Court has resolved that issue, the Supreme Court's treatment of it is going to affect my view of the merits, at least in part, because I feel like the US Supreme Court has some legitimacy in most of these circumstances in terms of informing us as to what the law means. So I guess one of the problems with coming up with a consensus, again, is that you may have some of us basically calling into question whether, for these difficult legal issues, we can really have a determinative answer at this stage.
Right, and that's precisely why we structured today in these 3 different time sequences, because, you know, with respect to the Pennsylvania hypothetical that we've been kicking around, the main issue is whether or not the federal judiciary should basically say no to the Pennsylvania Supreme Court in what it tried to do to remedy the perceived disenfranchisement of the absentee voters. And some of us might think that the correct answer to that federal law question is let the state Supreme Court's decision prevail, and that the 14th Amendment and Article 2 and the whole federal Constitution, properly interpreted, is not to supersede what the Pennsylvania Supreme Court wants. And so if we had a vote at the US Supreme Court on that question, we would vote to deny the Republican Party's motion, as it were. And yet, Lisa, to your point, when we get to scenario 2.1, it's built on the assumption that the federal judiciary has ruled the opposite way of what I just wanted. And that might affect my view as to what the right answer to those legal questions are, precisely because I accept, the US Supreme Court is authoritative on that issue, even if I would have dissented or voted the other way. So I agree there is a timing complexity and an institutional complexity, depending upon at what stage or in what procedural posture any of these issues arise. But I don't think that necessarily negates the utility of trying to segment these issues and taking them sequentially and saying, okay, at stage one, if the federal courts got this kind of claim, is there a right answer under federal law to whether the Pennsylvania Supreme Court acted improperly or not? Yet I don't know if, who's up? Go ahead.
Well, it was just me, Ned. I was just wondering if at this point we should sort of let this particular subject percolate. I know we need to kind of keep on our time schedule given the format we're using and be able to take a break in about 15 minutes. As Ned has suggested just now, and you all know, the other scenarios in this first session also relate to the second session, and we can certainly pick them up in that session and not have to introduce them all here. But Ned, should we just see if we can spend 12 to 14 minutes talking about scenario 2 now and the way in which a court might respond to that, so we're better positioned to then talk about how the Electoral Count Act issues might play out in Congress?
Yeah, I think that's a good idea. And if you don't mind, Steve, let me just really quickly put this second scenario on the table, because I think it's easier to describe and maybe easier to figure out what we think are the right answers. And this scenario is built on the concept of the so-called blue shift or late counted ballot scholarship that some of us have been involved in, which is a phenomenon where, again, with nothing going wrong, but just because of the way in which we've done changes to voting since 2000 and the Help America Vote Act of 2002, it's just much more likely that ballots are going to be counted not on election night, but subsequently during the canvassing process. And again, the Irvine report that Rick Hasson led really flagged this as a very important concern. And that report has a series of recommendations, both for the media and for the legal system, on how to better handle this. And this was under consideration long before the virus kind of overtook everything. So the fear is that, and this also builds on what was observed in Arizona and Florida in 2018, the fear is that we can imagine, for example, President Trump winning, as it were, or at least ahead on election night in the count of votes in a pivotal state, let's say Michigan, and yet that lead disappearing over the next week as additional ballots get counted. And President Trump tweeting, as he did with respect to the Florida election in 2018, saying, no, the initial count is good. Let's stop counting ballots because we've got an accurate count. Whereas the election officials say, wait a second, these are valid ballots. They need to be counted. And then you have a certified final result after canvassing that puts the Democrats on top. And yet Trump is still protesting that outcome. And because the Michigan legislature is in Republican hands, again, this is all hypothetical, but that's why we're talking about it now. What if the Michigan legislature says, you know what, we just don't trust late counted ballots, and so we're going to assert our power under the federal constitutional Article 2 to appoint electors directly. And so now we have this conflict between a certified result from the Secretary of State that says Biden won Michigan, but we have the legislature in Michigan saying, no, we're just going to, we don't trust that result. We're going to appoint the Republican electors. So now it's the Democrats who are now going to federal court, invoking the same concept of due process. Hey, don't change the rules. This is why we're having this scenario back to the other one, because now the Democrats are the plaintiffs, citing Roe versus Alabama and due process, saying that it would be unconstitutional for the Michigan legislature to do what it did. So that tees up, I hope, that scenario.
It looks like we have Derek and Fernita interested in commenting. Go ahead, Derek.
Great. Thanks, Steve and Ned and everyone for this great conference. So on this one, I like the question framed as should. It makes it easier for me to say no on a hypothetical like this one. I mean, not to get too far ahead to the January 6th question, right? But I mean, my view, this is sort of squarely the domain of Congress to decide what it's going to do. And for a federal court to step in is both, I think, wrong on the law in terms of its domain of authority and wrong practically, to step in as a deck action, tell the legislature, hey, you never should have done this, and wonder how that's going to play out, right? Are we going to enjoin the legislative appointed Republican slate of electors from meeting in late December, from sending their votes to the Senate or to Congress, from preventing Congress from counting them? Now, I mean, from the scenario, right, we also have federal statutes, right? So Title III, Section 2 is if the state has failed to make its choice on Election Day. And if the legislature, in its view, thinks we failed to make our choice, a la North Carolina's fraudulent congressional election, it's within its domain to find that. And if it says these weren't regularly given under Section 15, these were not regularly given votes, we want to provide the regularly given slate. On the merits, the legislature might be totally wrong, right? Which is not what I'm really challenging here. It's that this is something that they can send the second slate of electors and send it to Congress and let Congress sort this out. And in fact, I'm recalling how the 1960 election worked out, although I haven't looked at the state court decision, right, in Hawaii, where you have two competing slates of electors that go in, and there's litigation in state court. And I don't think the remedy was sought this way, but maybe it was, or someone can challenge me or correct me on this. But when the state court gets in there in Hawaii and says, well, here's our slate of electors, it appoints a third slate. It doesn't sort of provide a deck action saying one of them is right or one of them is wrong. It's providing sort of its own third slate that gets sent to Congress for Congress to sort it out. So in my view, and maybe this is sort of my Rudebush versus Hartke kind of approach of not thwarting the legislature in its ability to make a determination. But my preference is let the political branches fight it out. You've got the executive appointed slate on one, you've got the legislative appointed slate on another, and we'll let Congress sort it out come January 6th. But others might be free to disagree.
Yeah, thanks, Derek. I see at least 4 people ready. Fernita, Marty, Paul, Liza. So go ahead, Fernita.
Okay. I hate myself for making this point, but I can't help myself. I think that what the legislature has done violates Section 2 of the 14th Amendment, because what we have going on here is a situation where they have allowed an election, right? And so they're disenfranchising all of these people after the election. And so I think that that is a violation of Section 2, which explicitly applies to presidential elections. But I do think Derek might still be right that it might be still within the purview of Congress to sort all of this out. So I don't know if that affects the ability of the federal court to issue the declaratory judgment, but I do think in terms of the merits that there's an interest in Section 2 problem here. And I actually think it's the same problem that the National Popular Vote Initiative has, but we'll leave that for another day.
Thanks, Fernita. Marty, go ahead.
I have a question as not an election law expert for the rest of you, and that is whether this is primarily a federal constitutional issue, whether it's a statutory issue. Is it the case? What does it mean in Title III, Section 2, for a state to hold an election but fail to make a choice on Election Day? In your scenario, I think the state has made a choice, and I'm not sure what Congress had in mind by failing to make a choice. And so if you just looked at Section 2, it would seem that the legislature in your scenario has violated this federal statute. This is putting aside the question of who decides. And is Section 2 constitutional in that case? Or does the Constitution give the state legislature the power simply to disregard the will of the voters on Election Day? Forget your scenario. Simply the voters vote for Democratic electors and the Republican legislature says, we're not going to do that. We're going to go with Republican electors. Clearly that would violate Section 2. Is Section 2 unconstitutional? I'm sure someone's written about this, but I'm not familiar.
So the good news is we can get into all of this stuff in our second session because it relates to, as Derek says, what happens when things get to Congress. So I think the question here is whether or not a court should try to enjoin or declare invalid this legislative attempt to supersede the popular vote. But
and I guess I'm asking, Ned, what the substantive question for the court is. And I would think the first question is whether this violates Section 2 of the Title III. And then in addition, if so, is Section 2 of Title III unconstitutional?
Yeah, no, fair. And I want to let other people speak before we run to the end of 12:30. So, and we've got quite a queue. So let's Paul go and then Liza.
Thanks, Ned. It would seem to me that what the legislature is doing here is clearly unconstitutional. That you can't turn this issue over to the people to decide who to elect, and then after the fact, when there's no real reason to think the outcome is unclear, just decide you want to take the power away afterwards. That said, I think there is a serious question of whether the federal court would do anything about it at this stage. It's a real practical matter. It's not entirely clear to me that there's anybody you can sue in federal court. You can't sue a state legislature in federal court under the 11th Amendment. I mean, so unless you're going to enjoin their slate of electors or something, it seems to me there's a real problem there. And having thrown that out, the other question that I think is sort of lurking here undiscussed is the hypothetical seems to assume that the legislature can do this without the consent of the governor. That this is not like legislation where the governor could veto it, and that may be clear to everybody. It's not clear to me. I think he probably picked Michigan for that reason as a Democratic governor. So I'm sort of really asking the question of where does that question stand?
Oh no, you're absolutely right. That's embedded into the hypo is whether or not a legislature can appoint electors without gubernatorial involvement or not. I think that's something to be considered. All right, we've got Liza, Justin, and Norm in 4 minutes, I think. But these points can still come up. It's like we're not going to. You can bring if we don't finish the points now, we will definitely bring them up in the next session.
So I'll be very quick. My point dovetails on Paul's, which is that even if it were the case that the legislature could in fact start from scratch and appoint the slate of electors without getting the governor's signature, it's not operating in a vacuum. It's operating against an existing law that gives this right to the people to vote. And so what it would be doing is effectively repealing a state statute that's already on the books. And it would be repealing that statute without getting the governor's signature. And I would think that that would raise resentment issues under the state constitution.
Good point. Justin.
So to the extent that you were looking for consensus, I actually think this may be one of the most important places to seek consensus, because the procedural problems that other people have noted, who do you sue? Can you enjoin anything? Is this something that Congress should decide about what to do with the different slates of electors? I think that if you were looking for robust consensus among a group of people, across partisan bounds to study the issue to weigh in, this would be a place for a strong normative assessment, particularly when the federal courts might not be ideally empowered to make that assessment within their normal jurisdiction. So I think rather than, if I can suggest a change to the hypo on this, rather than should the court issue declaratory judgment, is this action unconstitutional could actually get you some of the practical consensus that you might be seeking from this group.
Very helpful. Norm.
Just a couple of points. One, it took me back to Bush v. Gore and the question of whether the court had any business intervening there, given that if there were issues of contested electors, there were all kinds of procedures for Congress to deal with it. And just thinking about what the Supreme Court would do under these circumstances, given this Supreme Court. But the second point I would make very quickly is I think this is one of the real nightmare scenarios that could very well take place. We could easily imagine state legislatures in a number of places deciding they didn't like the outcome of the election and shifting this, trying to shift it to Congress knowing or believing at that point that we might well get the House and Senate disagreeing over which slates of electors to accept, and leaving it to the House of Representatives then to decide who would become the president, and leaving it in a situation where we would not have anybody getting the 270 requisite electoral votes. So this one is worth, I think, spending a great deal of time on to try and set out some parameters in advance.
Well, thank you, Norm. That's a very nice point in which to take stock of where we are in today's event, because absolutely the next session, the next 90 minutes, which we will start up again in a half hour from now, will pick up on precisely that point. We'll be assuming that there are two competing sets of electoral votes coming from a state. Let's stick with Michigan for the moment. You know, one reflecting the popular vote, the other reflecting this legislative attempt to have an alternative slate, whether they have the power or not. But we'll assume that a court hasn't been able to enjoin it so that it does arrive in Congress, and then Congress does have to consider what to do. I think that will involve questions of the Electoral Count Act and the 12th Amendment, not just whether or not the House of Representatives gets to vote in the arcane procedure that was used in 1824, but whether there's some preliminary procedures that take place in Congress even before you get to that point. But that's our next discussion. So I'm delighted that the first 90 minutes have teed us up for what I think will be a very productive second 90 minutes. So with that, we will take a half-hour break, and we look forward to seeing you all back here promptly at, it would be 1 o'clock Eastern time, and I leave the rest of you to figure out what time that is in your own time zone. It is now 12:30 Eastern time, and we resume promptly at 1 o'clock Eastern.
And remember to mute your mics and cameras. Count Act, which, as you all know, and a few of you made brief reference to in our first session, is a disaster of a statute. What we thought we'd like to do is begin our discussion of this phase of the potential for some disputes around the presidential election by talking about the Michigan scenario that we concluded the first session with. So the scenario as it continues to play out in this second temporal phase of things involves a circumstance in which now Michigan has purported to send two contrasting slates of electoral votes to Congress. One would be the set of electoral votes cast by electors that the state, including the Secretary of State, has certified as the result of the election held on November 3rd, but after the completed count. The second set of electors would be electors whose votes, the second set of electoral votes would be votes cast by electors chosen by the legislature as an independent act after Election Day on the basis of the legislature's assertion that the election was no longer the way in which the state was making its choice for whatever reason. So we've got these two competing slates in Congress, and how should Congress respond and determine which of those two slates to recognize? Now, before we open the floor up for this, I know we had two other housekeeping things. I wanted to just mention again, for the benefit of those members of the audience who are attendees but not participants, that at this point we do not have the chat function enabled, and if you were with us the first session, you could detect or sense that we had plenty of discussion among the panelists, and we sort of ran out of time to be able to go through all the scenarios in that first session because of the range of ideas being generated. Again, we're going to begin this session without the chat feature available to the attendees. There's some possibility that we might be able to open it up later, but that's not the way in which we're proceeding as of now. And then Ned, I know you wanted to be able to make an additional remark before we open up the floor.
Yeah, I just had one thought, quick reflecting on our first 90 minutes. And I think this is a thought that both Rick Hasson and Rick Pildes would appreciate, which is to the extent that it's difficult to get consensus on how to handle some of these equal protection and due process issues that could arise in the context of a fight over the outcome, that's all the more reason to redouble efforts between now and November to try to put into place mechanisms that might prevent, avoid, or minimize the risk of those kind of disputes. So if there are ideas about how to better handle the issue of absentee voting or just the way voting would work so as not to put the pressure on a court like the Pennsylvania Supreme Court to try to deviate from state law to do something different, maybe those things can happen in advance, whether by legislation or even by litigation if it occurs now as opposed to in the heat of the moment. So I don't mean to revisit our conversation. I just think that one way to think about the takeaway from today is not just how to solve the particular issues that we're talking about today, but maybe how to prevent them from happening in the first place. So I just wanted to share that thought. Now, Steve, back to you and the Michigan scenario, which I do agree is the order of the business at the moment.
Yeah, and we obviously, in the course of talking about hypothetical 2.2, which is what happens to this competing slate of electors from Michigan when they reach Congress, that will give us opportunity, we're quite sure, if we want, to be able to also talk about the sort of parallel hypothetical involving what happens with the electoral votes coming out of Pennsylvania, but also the scenario 2.3, and then relatedly 1.3, which we didn't talk about in our first session, involving a situation in which Florida has, because of a hurricane that has dramatically interrupted election day itself, appointed electors through its legislature, and differences between that hypothetical and the Michigan hypothetical, especially when it reaches Congress. But let's start with the Michigan hypothetical and just see how our group of participants here, how you feel about the appropriate response to that. So the floor is yours. Who would like to get us started? So I see Derek is ready. So we'll go ahead and move to Derek and then proceed from there.
Yeah, well, I mean, since I opened up the last one and I want to offer the other side on this one, right? I think, and getting back to Justin's earlier point, right? I think unless you have some evidence of fraud, lack of regularity, whatever you want to put it there, it's pretty clear that Congress has the obligation to take the batch of electoral votes, the Democratic slate signed off by the executive, unless both houses of Congress agree not to count that slate. So that's a big task, in my view, to convince both houses not to count the regularly given ones or the presumptively regularly given ones. I think there were some comments in the last session, well, we're sort of disenfranchising a group of voters. Well, I mean, both slates are still going to Congress, right? It's worth noting it's not just one slate that's going, it's two slates. But I think in my view, Congress has the power in theory to be able to choose the Republican slate here. But based on the facts here, I think it's easy both on the law and on the procedural front to take the Democratic slate here.
Thanks, Derek. So I see we have Marty and Michael and Adav ready. So go ahead, Marty.
Well, maybe Michael's going to answer this question. I mean, I want to agree with Derek that the legal question is easy, but doesn't that sort of elide the whole McPherson versus Blacker question, which is whether the legislature has the authority to simply ignore what the electorate did and appoint its own electors. They have the, and I'm not sure what Congress would think the right answer to that question is, or the Republican dominated members of Congress or the state delegations. The Article 2 language is that the state shall appoint in such manner as the legislature may direct. It doesn't say shall appoint the electors that the legislature chooses, but shall appoint them in the manner the legislature may direct. I would think that that would require the legislature first to say something like, the manner will be our choice, and here's our choices. And if you take this McPherson versus Blacker argument seriously, which a majority of justices did in Bush versus Gore or Palm Beach, why isn't that a serious problem? Or at least, why doesn't that at least give a pretextual excuse to the Republican delegations in the House to do that?
Thanks, Marty. Michael, go ahead.
Sure, thank you. So I guess I have I also agree that applying the text of the Electoral Count Act, this seems to be a fairly straightforward case. I just wanted to flag a few issues that applying the Electoral Count Act presupposes that I think might be helpful just to put out there. The first is the question of whether the Congress that adopted the Electoral Count Act can entrench limitations on the discretion of future Congresses in exercising authority to count electoral votes that comes directly from the 12th Amendment, right? And so there's an argument that because the Constitution itself confers power on the chambers of Congress to count these votes, to determine their validity, to determine the outcome, statutory fetters on that authority, there's at least a question as to whether that's constitutional. A second issue with regard to the Electoral Count Act is because it's a statute, obviously you have the president involved in any attempt to amend or repeal it. If we look at Article 1, Section 5, right, each chamber of Congress has authority, has sole constitutional authority to determine its own rules of procedure. And so there's a separate question of whether Congress, the chambers of Congress, are free to simply choose to disregard what the Electoral Count Act says, precisely because they have this inalienable constitutional authority to determine their own procedural rules without having to go to the executive branch. And a related issue about the validity of, in particular, the safe harbor and the limitations on rejecting votes. And this is an issue that I think maybe more squarely comes up in one of the other scenarios that we're dealing with, but I just want to flag it here, is whether the Electoral Count Act, and in particular the safe harbor provisions, might be unconstitutional insofar as they deprive Congress of its authority to reject an outcome that itself violates the Constitution, right? So if the Constitution properly construed, you're right, obviously a loaded term, but whatever that means, if the Constitution properly construed would require certain votes to be counted, would require certain votes to be rejected, but the safe harbor provision of the federal statute were purporting to force Congress into an alternate outcome there, it's not entirely clear that a federal law could override the right to vote in this context, and that Congress could be statutorily required to approve of an outcome that either it thinks is constitutionally deficient, perhaps both it and courts would say is constitutionally deficient. And so I think a lot of the unsettled and potentially problematic issues here may not even necessarily be so much how do we apply this archaic and poorly worded statute, but rather to what extent is Congress actually bound by it or free to act in contravention of it, particularly if it thinks that it's enforcing constitutional rights by doing so.
Great, thanks, Michael. Adav.
I totally agree with Michael, actually, and just to spin it out a little further, I mean, I think there's an area where some consensus is probably possible, right? So there's the two prongs for the safe harbor, right? There's the timing and the compliance with pre-existing state law. And I think almost anything can be pitched as compliant with pre-existing state law. I think Justin sort of illustrated that in the prior segment by saying that even if a court comes in after the fact and imposes procedures that weren't in existence in the statute beforehand, you still make an argument that that's consistent with state law. So almost anything can be, but the one thing that clearly can't be is the legislature coming in after the fact and appointing its own slate. And there's no serious argument that that's consistent with pre-existing state law. So that slate can't get the safe harbor, but that doesn't resolve the question, because then you go to Michael's point of, is the safe harbor, A, is it constitutional? And B, even if it is, who's going to enforce it? And I think those are tricky questions, even if you get consensus on the first part.
John Fourier.
Yeah, so I'm going to identify myself with Derek's comments, both in the first session and this one, and also Michael's. I think if we stripped away all the law and went back to kind of root constitutional matters, we have legislatures which are responsible for somehow appointing or directing the appointment of electors. I suppose we have electors who actually cast their ballots, so I don't want to leave them out. And then we have Congress ultimately responsible for counting them. That's not to say that there aren't ways in which Congress can define its procedures, but I do think when one gets into Congress binding itself in certain ways, I think it's going to be hard to imagine both practically and also constitutionally whether some of these things stand up. I do so. I think not that I want to throw away the Electoral Count Act. I think it's helpful in some ways, but I mean, the bigger question is, we've decided that a state legislature has gone ahead and allowed an election to go forward, that then there are certain restrictions on it. And, at the end of the day, I think certainly politically, but also in many ways legally, we're going to say that state legislatures really should not be leaving that scheme behind, that everything should be done to save that scheme. But one further point is, so who would decide if a state legislature had gone too far and showed up and tried to appoint its electors, even though it had an election? I think that is a question I think courts would be really reluctant, and rightly so, to prevent a legislature from doing this, even though it would be a very bad idea, even though this is an extreme case. And so I guess I just wanted to think about the types of cases, because generally people think this is a bad idea, and I think they're right to, but I'm sure we could devise scenarios that would make everybody think there's some place where the legislature really should step in, that the other actors really did distort the election so badly, or something happened that was that really did justify the state legislature coming in. Again, I think that's probably not our inclination, but I think it's something that we should think about. So one thought is the third scenario you have, the one about the hurricane. I guess I wanted to push that even a little further. The hurricane in your scenario, did some bad things. It made it very hard to have the election resolved in a timely manner. Imagine really the whatever currents, the pandemic, the hurricane, the combination really prevents us from having an election at all, right? We have an election on the books. We can't have it at all. Well, what's left? How do these electors get appointed? Would a judge step in? Of course not. I mean, I think at that point, we might all say, hey, the legislature is still sitting there. It's not an ideal situation, but if literally we cannot hold an election, if not because of any maliciousness, but just because of the situation, we cannot hold an election, at base, that power of the state legislature to be able to appoint electors it's important, but also seems like it's the right thing to do. So I think thinking out the cases, which I think are very extreme, of when a legislature might come in and try to put on a hat of you put your party in the opposite position of different. You can think of New Hampshire, which has the opposite situation of these Midwestern states with a Republican governor and Republican supported state Secretary of State and a Democratic legislature. You could find some very extreme cases where maybe you would want this to be the case. The last thing I want to say is, people asked about the question of the legislature versus the legislative process, and that is a question I think that goes through lots of our jurisprudence, and so it's not absolutely resolved, but it certainly is. I mean, it's an oddity in a way that when legislatures decide to appoint directly, and when they did in the past, it was clear that the executive had no role. But once they pass a law that has an election, that is something that's through the legislative process. So the legislature, in deciding how they should be appointed, sometimes acts independently, but in this other way acts alone. And I'm not resolving that, but I guess I'm noting that as a bit of a paradox.
Thanks, John. So yes, I mean, we have the third hypothetical in this session, which presses the envelope, as if you will. I mean, John's teed up an even more extreme, and we didn't put that sort of most extreme scenario before you because we want it to be a little more challenging. The comments so far about the Michigan hypothetical, and I don't want to speak for most of you who haven't yet had a chance to weigh in on it, but those of you who have spoken so far seem to see a fair degree of consensus building around the Michigan one. So then the Florida one becomes the alternative, or the one in which maybe there's consensus there too, but it goes the other way, although it's not as easy to resolve as John's more extreme circumstance. And I don't mean to shift us to any alternative scenarios at all just yet, to the extent people still want to talk just about the Michigan scenario. And I know we still have Joel and Liza so far ready to talk about that one. So Joel, go ahead.
I was simply going to make the more general point that it would seem to me that with respect to the constitutionality of the Electoral Count Act, that the fact that it has been in place for and has been followed for 130 years and really was the product of a period of discussion and compromise over a period of a couple of decades before then, would argue in favor of its constitutionality, and particularly difficult to see sort of abandoning it in the context of trying to determine a particular election, which I think would raise some questions of legitimacy as well.
Yeah, useful point.
Thanks. Liza?
I was actually going to switch to the Florida scenario, so I'm happy to hold off. We want to stick on Michigan for a little bit.
Yeah, because I at least want to raise one more thing about Michigan, if I might, and I think it builds on Marty's point. I take it that it seems to me politically realistic to think that the Michigan legislature would actually attempt to exercise this putative power from McPherson versus Blacker and Article 2 and so forth, only if there was some plausible basis for trying to supersede the popular vote that otherwise exists. I mean, I take the most heartening lesson of what happened in the Kentucky gubernatorial election of just last year, when the incumbent governor kind of flirted with the idea that maybe the legislature would keep him in power even though the votes were not there. And his own party in the legislature said, no way, we actually care about counting votes even if they're against us. You know, it's a pretty good signal in American culture that despite all of our polarization, we do have a bedrock commitment to counting votes, and where it's pretty clear the outcome is, that'll prevail whether the incumbent loser likes it or not. So I think we need to at least sharpen the Michigan hypothetical to make it useful, to be that in some way, shape, or form, the politics of the moment has managed to make a cloud over the popular vote, even if election officials themselves would say, wait a second, we've got a valid result. Whether that's just because the president's been tweeting, or because the atmosphere between now and November has so rendered a segment of the population hostile to absentee voting and fearful of fraud in the form of absentee voting, such that any late counted ballots that are vote by mail are inherently suspicious. Or again, I don't mean to overly complicate this, but we could create a kind of hypothetical that is a mixture of the Michigan scenario with a little dollop of Philadelphia thrown in, right? Where there's been just enough problems in the administration of the voting process that, you know, people are worried whether it's an accurate reflection of the popular vote and so forth, that there's some credibility. It may be fairly fig leaf, but something is causing the Michigan legislature to question the popular vote. This takes us a little bit to where John Fortier was going. And on that point, I guess I want to come back to Derek and Michael and John, all to which all of you were saying, at least to some extent, you thought that as long as independently and objectively, the election officials, the election administrators are correct that the popular vote is an accurate count, that there is a true legal answer to which certificate Congress should adopt. And if that's true, then maybe the legal community can rally around that point, because what I fear is if there's been political pressure that's going to cause the Michigan legislature to want to supersede the popular vote, there's going to be political pressure in Congress for one chamber at least to try to do that too. And so that's where is there any point that legal intervention, not necessarily by a court, but by scholarship, can say, wait a second, there isn't actually a right answer to this question, that Congress should feel obligated to answer the question correctly, even if Congress obviously can do whatever it wants.
Ned, can I quickly just jump in here? Because you made the point about the election administrator having counted the votes correctly. But I think there's a distinction between, I think what we're feeling is the facts here don't really support any, that anything really particularly was wrong here, versus a decision of an election administrator. Yeah, that decision might be something you find very objectionable. And I can bring up election administrators on either side of the aisle who people would have said, well, they did that for bad purposes, they made the wrong decision. So we aren't talking about deferring to the election official. Here we're talking about just our judgment of the facts is that there was this election, there wasn't really any legitimate reason for the legislature to go to this very, very extreme measure, that they shouldn't have done it, but not because the election administrator said it, but because the election itself was more or less fine.
I think that's a fair point. And I think it relates to Lisa's point earlier, right? That even if you might have a view of the correct answer on an issue, do you as a scholar defer to institutional authority? So suppose you thought that there were problems in Michigan that made you nervous about the popular vote, but that Jocelyn Benson, Secretary of State, and the legal authorities in Michigan have certified the outcome in Michigan is in favor of Biden. And now the legislature steps in and says, hey, we don't like that certification. We think it's wrong. To what extent should one's evaluation of that scenario be whether you think Jocelyn Benson's correct or incorrect, or do you defer to her simply because under Michigan law, she and her canvassing board has the institutional authority to say what the count of the popular vote is? I mean, I think you can play it both ways. I guess what I'm asking you and Derek and Michael and everybody is, at what point do you think it is appropriate to tell Congress there's a correct legal answer to what Michigan has done, whether you in Congress like it or not? Because Michigan is sending you this certificate that Jocelyn Benson has signed and the governor has signed, that is what Congress must accept as a matter of law. Now, what Congress does as a matter of political power is different, but the legal community can tell Congress there is a correct answer to this legal question. And that's regardless of the fact that there's already a partisan dispute between the legislature in Michigan on the one hand and the Secretary of State and the governor on the other hand.
So we have Liza and then 4 others at this point. Liza, do you want to weigh in now or come back when we're all?
I'm going to defer for now because this is a great discussion, and at some point if we circle back to
we'll get you back. Okay. So then I have Sam and Michael, followed by Josh and Marty. So Sam, go ahead.
Well, I think that this is a very difficult set of questions once you get into the Congress and you get after the election period. So one question is, what can be done ahead of time in order to try to forestall this? And this goes back to a question that Marty Lederman asked earlier this morning about the role of Congress. I don't think that the Electoral Count Act is well-settled law. It has been on the books for a long time. It's never been applied. The closest we came to it was its spiritual invocation in Bush versus Gore. But it is hardly a blueprint for how institutional actors have settled themselves. I think that one way of getting at this ex ante is not through the presidential election as such, but through the normal powers of Congress over the time, place, and manner of congressional elections. And that is to try to push as much as possible for specification of emergency procedures under Congress's ordinary authority. I think that as a political matter, when elections go forward pursuant to specified existing practices, even if they're extraordinary emergency practices, there is a political cultural dynamic that would make it very difficult to preempt the will of the voters by simply the legislature taking it away from them. And that Congress does have authority, clear authority, with regard to the congressional elections, which obviously take place on the same day and in the same fashion as the presidential election. But once you get beyond that, in the heat of our polarized environment where everything is up for grabs on, it's our president or perfidy, I think it's very difficult to think that the formal requirements of the Electoral Count Act, which have never been tested, not even constitutionally, are going to override the language of Article 2, the intimations of McPherson versus Blacker. I just think as a practical matter that the temptation will be overwhelming for partisans to deliver a partisan result, which may be the inevitable and perhaps even the best kind of consequence. I'm not fond of it, but that could be the case. I think that the place to push is on clear federal standards for, other federal elections.
Wait, can I jump in real quick? So this is Derek. Sam, in 2000, members of Congress repeatedly on the floor tried to object to counting Florida's electoral votes, and Al Gore said improper under the Electoral Count Act. And then in 2005, they challenged Ohio's electors, Democrats in both the House and the Senate. They debated for 2 hours. They came back. They counted Ohio's votes. In 2017, it was a parade of objections on the floor of Congress with Joe Biden saying, it's over under the Electoral Count Act. So I agree, especially the two slate question is sort of an open, highly debatable contest. But I do think the Electoral Count Act has served its function the last 3 times Republicans have been elected, where Democrats have been contesting the election on the floor of Congress. No?
I think that there's always a question about what one says rhetorically and what actually is driving the result. I think that the overriding of the seemingly expressed popular will by legislative fiat, either at the state or at the congressional level, is thus far a radical departure from American norms. I think that's what's driving the result. I doubt if a single member of Congress had any idea what the Electoral Count Act was or what its provisions might say.
Michael, go ahead.
So first of all, I think this conversation is absolutely fascinating, and I think we're really hitting on a lot of important issues. The thing that I wanted to bring out, building on John's expansion of the hypothetical, right? You could imagine situations where the legislature is stepping in to say, we're appointing our own slate of electors because in order to reflect the accurate outcome of the election as conducted in accordance with state law, right? I mean, you could, whether that deviation from state law happens at the behest of the judiciary, right? You could imagine, to go back to the Pennsylvania example, a Pennsylvania court saying, we're expanding the deadline for absentee voting by an additional 2 weeks because of the delays. And so the Pennsylvania legislature then would step in and say, we are appointing a slate of electors reflecting what we perceive to be the accurate outcome based on the election as it was conducted in accordance with state statute, and not with what appears to be this judicial deviation from state statute. You could imagine even a governor, right? There are many states that allow governors to suspend state statutes and state statutory deadlines during declared emergencies. If we're still in a state of emergency in COVID, you could imagine a governor potentially saying, we had low turnout on election day. The percentage of people who cast ballots in the presidential election was historically low, so I'm exercising my authority to allow for additional modes of voting. Or I'm getting rid of signature requirements. So all of the absentee ballots that would have been rejected due to signature requirements now have to be counted. And so again, right, you could imagine the legislature stepping in and saying, we're appointing a slate of electors reflecting what state law, what the election code actually required, as opposed to these unexpected changes. And quite frankly, right, it might be their perception of state law is actually inaccurate given the breadth of their state emergency statute. But I think it raises very difficult state level separation of powers issues that I am uncertain. I think you might have to address before being able to determine that the state legislature's action is actually improper, as opposed to trying to reflect the outcome of the election based on what state statutes required as of election day.
Thanks, Michael. I have Josh and Marty next, and then several more. So Josh, go ahead.
So I want to go back to Ned's question of, is there a consensus legal opinion, even if Congress does whatever it's going to do politically, as Sam notes? And to me, this is where the due process principles, I think, come most to their forefront. And this might be just echoing something that I think it was Eliza that said before, but there's a meaningful difference, I think, between a state legislature saying at the outset, we're just going to hereby going to appoint our electors as we see fit, and a state legislature coming in after election day and saying, we don't think the result is what is accurately reflected or what should have been reflected, or all the scenarios that Michael just pointed out. And to me, that raises serious due process concerns that I don't think have been addressed enough, by the courts, especially when it's thought of the right to vote as an equal protection, and the statement from Bush v. Gore. But I don't think that saying it's a due process violation on an individual's right to vote, it gets into McPherson versus Blacker concerns, because again, you have a situation where the legislature is essentially undoing what it had previously done. The baseline is the legislature starts off by saying, we're going to hereby appoint our electoral college votes by the popular will of the state, whether it's through district-based or ranked choice voting or the winner take all, as most states do. And so when the legislature goes in and changes that, then you have the overarching due process concerns on the right to vote that I think have to come into the analysis, and I think suggest that the legislature cannot act in this way, even under Article 2.
Thanks, Josh. So Marty and then Genevieve.
So on that point, and Ned, your idea again that we could reach what you called consensus within the legal community. The legal community includes all of the lawyers who litigated on behalf of George Bush in 2000, and those who have been litigating on behalf of the Wisconsin legislature in the last few weeks, and those who have been appointed to Article 3 positions. Who have upheld those sorts of claims. And no, so I don't think we could get any sort of consensus. But then I was sort of heartened that Sam suggests that maybe Congress could actually do something, putting aside the McPherson versus Blacker problem, as limits on what Congress can do. Congress might do something if this is only pitched in terms of regulating congressional elections rather than presidential elections. I suppose maybe, Sam, and I hope you're right about that, but if that's ever going to happen, I would think there would only be impetus to do so if and when one day, when our grandchildren are running things and there's a Democratic president, House and Senate all at one time. Until then, I have a hard time imagining it because every time I suggest it on the election law list, I get ridiculed. And it's very telling to me that Rick's wonderful report that he put out last week doesn't breathe a word about any possibility of congressional regulation of elections.
So I'll just jump in real quick, and then, because I see we've got the queue, I don't think I'm so naive or idealistic to not recognize the political realities, Marty, that you're talking about. You know, and consensus, you know, may not be the right word. It is a term in Rick's report, so I want to take it seriously to that extent. You know, my biggest lesson in the 1876 story is it was partisanship all the way down until the very end, and the very end was within 48 hours of Inauguration Day. And you know, this relates more to session 3 than session 2, but you know, my big fear is that as a country, we don't know our history well enough to know that we came within 48 hours of Inauguration Day with 2 people claiming to be president and the incumbent thinking about martial law, that is Ulysses Grant, because he was worried that there were going to be 2 simultaneous inauguration sessions. And to replicate that kind of thing on January 18, 2021, in an era with nuclear codes, seems to me an altogether more problematic scenario than even the dire circumstances of March 1st, 1877. And so it may be, you know, a Don Quixote quixotic effort to try to wrestle these legal problems into the ground, but I feel some responsibility to say, you know, we've actually been there as a country once before and it was not pretty. And there may be no avoiding it if we go down that road again, but I think to the extent that we spend some time wondering how the Electoral Count Act works, even though it's dusty, and how you can settle issues before January 6th to know that they're right answers to what Congress is supposed to do, is it worth thinking about at least a little bit. So sorry for that interlude. Yeah.
I agree, Ned, but I think even within this august group, I mean, I saw Michael post to the chat that he's got a new article up on SSRN suggesting that the 19th century understanding was that state legislatures can supersede popular vote choices, or some. I don't want to overstate it, Michael. I haven't read the article, but so I'm not sure that even here we would ever get that kind of a consensus. But I hope I'm wrong. Perhaps you're right, Ned.
Can I just quickly ask both Marty and Sam? You're looking to congressional elections. I know what you mean, I think, by that, but on the other hand, just Congress is, the House and Senate are the final judge of their own elections. In some ways, they can do much more than Congress can do in a presidential election, in the sense that they can bring the ballots to themselves, decide everything, every election administration question. They're not just deciding whether to accept the decision of the state legislature or another slate. They can be intimately involved. So what is it actually that you were hoping to get out of moving towards a more congressional look at this?
I think that the checks on what Congress can do are ultimately political, cultural understandings of the importance of the right to vote. I think that it came as a shock to many when the Supreme Court in Bush v. Gore said there is no constitutional right to vote for president. That seems discordant with our popular understanding. So to the extent that emergency provisions on, just for example, who has authority on the federal elections, on the congressional elections, to designate the absentee ballots or anything of that sort. I mean, we'd have to get into technical details of the division of labor between Congress and the state authorities, but anything that's done to regularize would make the presidential election part of a properly conducted election. And I think that that would have a cultural political weight that otherwise would leave everything to legal restrictions. And John, I agree with you that it doesn't seem that there are any legal restrictions on Congress once it acts in that kind of plenary capacity as the determinant not only of the outcome, but of the rules by which they arrive at the outcomes.
We should go to Genevieve, I think. We've got quite a list of hands, so let's get to them.
Yeah, and sorry, going back a few points, and maybe I'm just sort of restating what I think it was Josh said, but it just, and I'd be curious to hear Michael's response to this in particular. It just strikes me that the legislature, in having exercised its authority to make a decision via the popular vote, essentially deferring to the popular vote, has really given up the power to interpret state law, or interpret whether or not the election has been conducted in the way it thinks is consistent with law, and that sort of as a matter of rule of law or separation of powers or what have you, that is for the courts to decide, and that really it only makes sense for the legislature to be able to step back in where there really is a failure to make a determination, where the courts can't decide or the like. And that strikes me as not a very radical proposition, and maybe consistent with sort of political cultural expectations, but I'm just curious and wanted to push on Michael's point on that a little bit.
And then I see Rick Pildes.
All of this discussion, makes me nervous, as I assume it makes all of us nervous, because it drives home how quickly we can spiral into this dynamic in our current polarized and existential political culture, in which there are no effective legal structures that are going to govern if we get into some of these kinds of disputes. And although maybe this is a little askew to the specific hypothetical, what keeps occurring to me is these are all further reasons that we need to be thinking about what I would call sort of more the structural integrity of the election, and perhaps in ways that are at odds with kind of protecting individual right to vote sorts of concerns. Now, of course, I want everybody to be able to vote, and I want the rules to be, flexible and accommodating, and all of that, especially under emergency circumstances. But I think that this discussion drives home that the more uncertainty there is that extends beyond election day, the more rules are changed at the last minute, whether by courts that think they're doing things in good faith, and are worried about protecting the individual right to vote of a few thousand people who didn't get the ballots they requested for absentee voting and the like. The more that opens up all of the capacity to destabilize the result. And I think there aren't a lot of places other than groups like this that actually focus primarily on the structural integrity of the election. Most of the groups that litigate are much more focused on either their own partisan concerns, if this litigation is done on behalf of the political parties, or they're concerned about the rights of individual voters. But I think this whole conversation drives home to me how profound the tension can end up being in the context in which we're operating between doing everything we can, including changes in rules at the last minute, to try to accommodate each and every individual voter, and opening up the legitimacy, at least as it's perceived by one set of partisans, about the outcome. And I'm not sure really, I think it's a very important part of this general discussion, the tension between doing everything we can at the last minute to maximize access to the ballot box, which again, I'm generally in favor of, but in the context that we're operating in, you can see from this discussion how quickly those kinds of changes can become the excuse for kind of blowing up the whole election. And that's part of what I'm taking away from this discussion.
Yeah, thanks. And I like very much the framing of the tension there that you've articulated. And I would just sort of add as a wrinkle to it, with the notion that we don't want to be making changes right up to the last minute simply to enfranchise every last person makes sense. We need to do this well in advance. We have an emergency, then the tension really becomes present for us, and we have to wrestle with it given the emergency. So I know we have Norm and Liza waiting.
Yeah.
Norm?
So just to reinforce some of these points, but also to raise scenarios a little bit beyond what John had raised. We know that we might end up with a pandemic that hits different parts of states and different parts of the country in different ways in October and November. It's possible that we could see a shutdown of all polling places in Detroit, in Milwaukee. Milwaukee seems to be dealing with it by saying that all 300,000 voters are going to get postage paid absentee ballots in advance. But imagine scenarios, and these of course affect Senate and House elections as well. Imagine an election in Michigan where there are no votes cast on election day in Detroit, and we don't have provisions in advance for other forms of voting. You could argue that the state legislature under those circumstances legitimately could step in and say this was not a complete election. Voters didn't have those opportunities. We'll make the choices. You can imagine that happening in a number of different states. And then you can imagine a Senate which has its partisan balance affected by a whole series of elections where a bunch of voters couldn't vote. And the idea that they can settle disputes in their own elections takes on a very different force when senators are sworn in on January 3rd who might not be legitimate senators if we were actually to have all those votes cast. So I raised those scenarios, some things of which could be done just by the way that pandemics or hurricanes or other things play out, some of which can be manipulated by political actors selectively to close polling places and create all these crises of legitimacy. And what that says to me is, beyond all of these fascinating legal questions that we're raising, we need to get as many forces as we can mobilized to make sure there are alternative voting procedures in place everywhere before any of these nightmares play out. And that takes us back to some of the first discussion. It's a question of what kinds of mail-in ballots, of whether there is a postal service to be able to deal with them, of whether the resources are there, but pressure on Congress, including from a large group of people with at least some legitimacy, it seems to me may transcend a lot of the legal issues we're raising.
I'm going to just jump in real quick, Norm. I think those are important points. You know, we wrestled here in devising the scenarios whether we should complicate any of them by adding the possibility that a Senate election or a couple of Senate elections could affect the presidency as well, because you're right. I mean, if you have a disputed Senate seat along the lines of the Norm Coleman, Al Franken litigation that took 8 months before Al Franken was seated, and it turned out that partisan control over the US Senate depended upon the resolution of that dispute. You know, on January 3rd, 4th, 5th, and 6th, the Senate might be, you know, in itself in gridlock, and therefore unable to kind of organize itself in any sensible way to address some of the issues that might come up under the Electoral Count Act, whether the Senate is supposed to act as a body pursuant to those procedures. So that was a level of complexity we decided to leave out of the written version of the scenarios in the first instance. But I think it's fair for us, you know, we've got about 40 minutes, not quite, left to think again about, you know, in this middle period between when the electors themselves meet and January 6th, you know, we're contemplating, at least with the Michigan hypo and any variation on it, you know, this competition of two different submissions from the same state. And then the real question is whether law applies or just politics. To go back to Marty's question and really Norm's. And so, and I was interested in the fact that, again, early in today's discussion, in this session, Derek and Michael and John and maybe others thought that at least as to some versions of this, there were legal answers worth identifying, even if the politics in Congress might resist those answers. Do we share that view, or are we now pushing back against this view and thinking that politics is going to engulf this no matter what? Adav, you've had your hand up, so.
Eliza, yeah, sorry, go ahead.
No, I had my hand up and then I took it down. I had my hand up for the Michigan thing, took it down, and then kind of realized based on what you just said, Ned, that I just want to jump in quickly and say the question of whether law applies or doesn't apply is itself a legal question, in the sense that I think a lot of what we're asking is whether Congress can be bound by the Electoral Count Act. And that itself is a legal question, right? Whether Congress can be bound by it, whether it's enforceable. Which is not to say that if the Supreme Court were to resolve that question, Congress would necessarily abide by it, and then I guess we'd be back in the land of politics. But I do kind of feel like, are we assuming that the courts would not decide this, that they would say it's a political question, therefore they can't even decide it? Because I guess I do feel like there are certainly legal questions that would be important, if not dispositive.
Real quick, my own answer to that is there are legal issues that are sometimes legal issues, not political issues, even if they're not cognizable in court. So that if Steve used to work in the Senate Legal Counsel's office, so he should speak to this, but I could imagine if that office got the question, what's the correct legal answer to this issue that's being raised, that could be analyzed as a legal issue internally to the congressional body that's different from what the politics are. But anyway, go back to the queue.
Adav.
I wonder if the resolution, or the high-level resolution to the tension that Rick mentioned and Norm was talking about, is sort of a chronological one, in that then the tension between sort of enfranchisement and rule of law / legitimacy. I mean, is the resolution that up to Election Day and through Election Day and through the tabulation process and any litigation or administrative processes that are going on, we argue for and support full enfranchisement. But once those processes conclude, even if they conclude in a way that doesn't lead to the more little d democratic result, then we respect the rule of law. All right, the court ruled, and it was 5-4, and it was a bad decision, but we respect the rule of law. Or the Electoral Count Act was followed, and it led to the non-democratic result, but that was the rule of law. And maybe the tension doesn't actually arise simultaneously in that process.
Thanks. I'll offer just a quick reflection in response to Ned's observation of my time in the Senate. And I'll contextualize it in terms of the Clinton impeachment trial, which was, sure, members of the Senate were, or at least some members of the Senate, were curious, interested in understanding what a legal principle might be. I mean, in particular, they were asking what treason, bribery, and other high crimes and misdemeanors might mean as a legal historical matter. At the same time that many senators were asking that question, they wanted it not because they were going to be bound by it. They wanted it in order to be able to figure out how it factored into their political judgment. Now, maybe we should turn to, unless people want to keep talking about what we've been talking about lately, to the Florida hypothetical and the ways in which that offers some contrasting issues, arguably, and that would mean going back to Liza to see what Liza was thinking about the Florida scenario. So Liza,
Yeah, thanks. So to me, the Florida scenario, and this is before we get to Congress actually, raises some questions about the meaning of 3 U.S.C. 1 and 3 U.S.C. 2, actually going back a little bit to what Marty was saying earlier as well, which is to say, at what point would you say that a violation of 3 U.S.C. 1 has occurred? And at what point and what is necessary to trigger 3 USC 2. So if a state were to cancel if a governor were to cancel because of an emergency, a hurricane, or COVID-19, all in-person voting on November 3rd, at what point would you say that's a violation of 3 USC 1? And if you have a state where there is, everybody gets an early mail-in ballot, and the decision is made well ahead of time to cancel votes on that day, and they're just going to count all the mail-in ballots on November 3rd, then presumably 3 USC 1 is satisfied. But if you're in a state with very, very limited absentee or mail-in balloting, and in-person voting is canceled on the day of the election, and maybe the cancellation happens that day or just the day before, I mean, is that not functionally a cancellation or a postponement that would be in violation of 3 USC 1 and could not necessarily be cured? And then this gets to what the heck 3 USC 2 means anyway. What does it mean to have an election and fail and have it does not work, in the sense of, are you actually under that statute if there is a hurricane the day before, and there you are with the state completely devastated and clearly no ability for anybody to vote in person. But if on that day you cancel it, are you still going to run afoul of 3 USC 1 because you haven't actually held the election on the 3rd of November and just failed to make a choice? Are you forced to say that people have to go out and try to vote on November 3rd, and then when they, have trees fall on them or whatever, then you say, well, we failed to make a choice? I mean, that seems crazy. But on the other hand, that's sort of what it seems to be implying. So I have just a lot of interpretive questions, and I want to flag for everybody who hasn't figured it out yet that I'm not really an election law expert, but I have a lot of questions about what those two provisions, both separately and read together, would even mean in the context of the hypothetical, the Florida scenario.
Great, thanks, Liza. I know Michael was interested in some reactions. Michael?
Sure. I just wanted to make two points on this. The first, in response to Liza's point, I think that there is a mix of just a bare minimum of political reality here, right? If you look at most jurisdictions, historically, there are numerous jurisdictions that have single-digit percentages in terms of how many people vote absentee, right? If you look across the nation, the strong majority of jurisdictions, you're talking about 5, 10, maybe 15% of people vote absentee ballots. The overwhelming majority of ballots in most places tend to be cast in person. And so I think that just as a matter of political reality, if you had an unexpected disaster, if you had an unexpected emergency, right, or the next Hurricane Katrina, an earthquake, whatever, that struck the day before election day, election morning, that prevented in-person voting, just as a matter of political reality, nobody's going to accept a result encompassing 5 to 10% of the electorate as the final electorate. I think people will construe 3 USC 2 consistent with what I've been finding in the legislative history as a secondary purpose of it. Its main purpose dealt with runoff elections, allowing states to have absolute majority requirements for presidential electors. But there was also an allusion to Virginia's well-known flooding problem, apparently, that had come up as well. I think I think that 3 USC 2 would be construed consistent with its text, consistent with the legislative history, as encompassing those types of emergencies. What I took away as the really hard question posed by this scenario was viewing the one slate of electors scenario as a lesser of two evils situation, right? If Congress has 2 slates of presidential electors to pick from, if it thinks that there's a constitutional problem with one of them, if it thinks that there's some sort of practical problem with one of them, putting aside the safe harbor, it at least has another way of measuring the popular will of that state, allowing the people of that state to participate in the presidential election, and it can go with the other slate of votes. If you only have one slate of electoral votes to pick from, your only options are count the votes even though you might think it's the wrong outcome, even though you think a chunk of the population might have been not had adequate opportunity to vote, even if you think that some votes have been unconstitutionally added into that or excluded from that total. Or your only other alternative, at least as far as the Electoral Count Act tells us, is to disregard it, thereby cutting that state entirely out of that presidential election. And so you get into a lesser of two evils situation, which I don't have a clear answer to, which is if your whole goal is to protect those voters' rights, the rights of the voters within that jurisdiction, if your whole goal is to ensure a free and fair presidential election, what is the best outcome? To count the votes that you think are deeply problematic, that you're not sure if they accurately reflect the popular will of that state, or just to throw them out, which as I read, and I know that CRS takes a different view on this, but I think would change the entire presidential election, because now you're shrinking the number of electoral votes, you're shrinking what constitutes a majority, you're potentially changing the outcome of the presidential election, and you're wholly depriving the people of that state of the chance to have a voice. I don't know I think that's something that's worth discussing.
Liza, did you want to come back on that?
Yeah, just really quickly, I want to point out that if we are in, this is not directly responsive, Michael, but just to point out that if we are in fact in 3 U.S.C. 2 land, then I guess to state the obvious, it's not like the only solution that the legislature could put in place at that point is to pick for itself the slate of electors. I mean, at that point, it could postpone the election, right? It could hold the election a week later once the debris had been cleared or whatever the case might be. So it's once you get to Congress with the one slate of electors, yes, you have this kind of Hobson's choice, but you don't necessarily have that at the time that the legislature steps in.
Yeah, although I'll just say, I mean, I like the idea of having a second chance at voting to remedy the failure to vote, which I think could be practical for congressional elections or gubernatorial elections or whatever. The deadlines under the congressional statute for the Electoral College are incredibly tight. I mean, the safe harbor date comes exactly 5 weeks after November 3rd. And then the meeting of the electors is Monday, December 14th, and the Constitution requires that be in every state. So unless the state figures out the remedial day of going to the polls after a terrible earthquake or hurricane, I think as a practical matter, it's going to be hard to hold a second vote for a popular vote for the presidency, even if you could hold a popular vote for other offices. So there's going to be some validity to the idea that there might need to be a different form of remediation. I'd be curious, I've been talking to a couple of you folks in emails over the last few days on this, and I'd be just curious as to what other people think about whether or not in the Florida scenario, it would be possible to have a re-vote of the popular vote for presidency if there's been a failure to vote on November 3rd.
Justin, go ahead.
So I'm going to agree with two things, or make two quick points. One is that if the Florida scenario in any way reflects how Ned and or Steve would write their final exams, I would be terrified to be a student in their class. And the second is that I'm one of those people who was corresponding with Ned about the other alternatives and votes for state legislature or for Congress or for governor. And I think those are instructive, again, going back to first principles. I think that we'd all agree that because there's another option, that is to postpone the elections, that the Florida legislature could not simply appoint themselves in the Florida scenario, right? They couldn't just decide that they were leading in the polls. And so each of us Florida legislators are reappointed simply by fiat, because that's the way the polls shape out. And I take it that we'd have the same instinct for Congress, that if the election can be postponed, if we can have it January, February, or March, that's far superior to determining what the will of the people actually reflects than going forward with some misshapen assumption about the will of the people on November 3rd. And if that's true, and maybe there's disagreement on that point, if that's true, then that to me is incredibly informative about what kind of election did or did not happen in the Florida scenario. That is, if we think that the only option for choosing members of the state legislature or for choosing members of Congress is to have a revote, then that to me is a pretty strong indication that we think, at least normatively, that a legitimate vote or a legitimate selection mechanism does not exist on November 3rd. And if that's the case, then we get into the remedial questions about what we do if a legitimate election, if a legitimate slate of electors cannot be chosen by Florida on November 3rd. I think we're in the scenario that Michael put forward on Congress needing to decide whether they're going to simply not count any electoral slate from Florida. But I think thinking about the problem of why we would not accept a similar scenario in terms of state legislative or congressional election to what you've designed for Florida here actually makes me think that we shouldn't accept a similar substitute for president.
Thanks, Justin. So I don't have anybody in the queue.
If there's nobody in the queue, can I jump in and say one thing, which is just one obvious difference in those two scenarios is just that, which doesn't actually in any way undercut the point you just made, Justin, but it's just, you know, you're going to know what the results were, presumably, of the presidential election in all the other states, right? And that's going to be something that affects the presidential race, but wouldn't affect the state and local races. So they're not completely, you know, they're not on even footing in terms of whether the remedy makes sense in one context or not the other.
Sure, it would absolutely, totally agree that you're going to be operating in that scenario with the full knowledge of exactly who wins or who loses after the fact, and that's the worst case scenario. But I just mean, if we're trying to establish whether an election was validly held or whether a different selection mechanism for the people chosen on the 3rd is valid or not, that thinking about the way we treat that election for other offices is actually, it might help regard what the right answer is, even if the right answer then unfolds in the context of knowing exactly how the broader selection pans out.
Makes sense.
So I now have Norm and then Rebecca and Paul. So Norm, go ahead.
So there are just some really interesting questions here. Let's say that this was just the Florida scenario and a devastating natural disaster that took out a portion of one state or all of one state. Presumably under those circumstances, Congress could assemble very quickly and change the law to allow a new election or a revote in Florida, which presumably would have to take place within a very short time frame to meet all of the other statutory and but particularly the constitutional requirements. But let's say that it is a pandemic issue that affects more than one state, or even if it affects one state, but Congress can't get back to Washington to assemble. So I would actually bring us back around to the issues that many of us have been dealing with for a while now and are dealing with right now, which is what do we do if Congress doesn't enact some form of remote voting or the ability to assemble? It would have to be very, very quickly. And of course, logistically, just to hold an election within a matter of a week, getting all the polling places together and back again, or a couple of weeks, makes it very, very difficult. But it certainly suggests that this is a set of issues that they ought to be contemplating now, or at least create some mechanism where the decision could be made very quickly, even if it were not done by assembling back in Washington and changing the law to enable another vote.
Thanks, Norm. So, Rebecca.
Yeah, I just wondered as I'm sort of listening to this, you know, states are gearing up, of course, to have as much absentee voting as possible. And I'm wondering if it was a Florida type scenario and you had a high level of absentee votes already cast, say on a level that was, you know, similar to participation rates in other low turnout elections, would you necessarily need to have, or what, is there a threshold at which point people could agree that you wouldn't need to have an election given, you know, extenuating circumstances?
Well, that gets back to what I was suggesting earlier, that if we had a provision in place for very, very substantial vote by mail in advance, and an understanding that there might be a set of issues that could create a problem on election day, you'd get many more of those votes cast, and you might be able to avoid some of these other nightmares.
For sure.
Paul.
Yeah, I was going to make essentially the same point as Rebecca, that in Florida, they have early voting for a minimum of a week. They may very well have a massive amount of voting by mail by November. We saw a lot of both of those in the Florida primary this year, where the turnout didn't go down. In a situation where you come relatively close to the expected turnout for the whole election with those two sources of voting, and given the problematic nature of either having the legislature just pick them or having the presidential election after November 3rd in a given state, you could make a pretty good argument that the best, least bad option is just to count what votes were cast. And it doesn't mean the legislature has to do it or that there's a remedy if it doesn't, but that's the right answer.
Hey, can I jump in with a variation on the Florida scenario that picks up on a comment by a couple of you that the Electoral Count Act might be unconstitutional? Because I'm curious as to what reasons people think that the Electoral Count Act might be unconstitutional, and then what would be the consequences of that belief if on January 6th we're in the 12th Amendment joint session of Congress where we have a live dispute over, votes coming from a state. And so I can imagine a situation in which, let's say, the Florida legislature has appointed electors directly, and there has not been the kind of revote that Liza or Justin or others of us contemplate. And let's again imagine that the partisan control of both the Senate and the House happens to be in Democratic Party hands. And so they interpret the Electoral Count Act to mean that they can disqualify the single slate of electors from Florida as an inappropriate slate because it was just a legislative appointment, and under the terms of 3 U.S.C. 15, if both chambers reject a certificate, it's rejected. So they say they're going to do that. But then the president of the Senate on January 6th, who happens to be the Vice President of the United States, says, well, I believe the Electoral Count Act is unconstitutional, and therefore the two chambers don't have the right to reject a certificate that I think is a valid certificate, so I'm going to accept that certificate and count it. So if we have a genuine view that the Electoral Count Act is unconstitutional, how would our legal system begin to process that kind of divide between the two chambers of Congress wanting to do X and the president of the Senate wanting to do Y?
So I see Lawrence and Michael and Rick ready to respond in some fashion. Lawrence, go ahead.
Actually, I wasn't going to respond. This was just a question I had arising from Rebecca and Paul's interventions, which was just whether it's possible to specify what the minimum threshold is for the purposes of determining whether a vote has taken place or not, or whether it's been a failed vote. I don't know if maybe Michael also has some kind of insight into that.
All right, we'll let that linger as well. And go ahead, Michael.
Okay, just to briefly answer Lawrence's question, New York State actually has an election emergency statute that says if less than, I believe it's 20% of the expected vote for an election winds up coming in, and it's been a while since I went back and looked at it, so I assume that they compare presidential to presidential, congressional to past congressional, but basically if there's less than 20% of some usual or expected threshold, then as a matter of state law, they have a new election. And again, it's been a while since I looked at the statute, so I'd want to see exactly like what time frames they have, if they have any sort of limitations on that. But I haven't seen anything else anywhere in other states' election codes that resembles that. I just hopped in initially to answer Ned's question about what potential constitutional concerns could there be with the ECA. And I want to emphasize, I don't have a view on this yet, so I'm just specifying potential arguments that could be raised, not necessarily defending them. The first argument would be entrenchment, that because Article 2 and the 12th Amendment directly give power from the Constitution specifically to the joint session of Congress to count the electoral ballots, other sources of law such as state statutes would be legally incompetent to impose limitations on that constitutional authority. Secondly would be the notion that, again, as I had mentioned before, because the president is involved in the legislative process, you can't have laws that trump states, or that's trump Congress's ability to determine its own rules. So if the joint session of Congress wanted to adopt rules that conflicted with the Electoral Count Act, those rules would supersede the act, because you can't, under Article 1, Section 5, the chambers themselves have plenary authority to determine how they go about conducting their proceedings. Third would be the substantive, more limited argument that a federal statute can't require the counting of unconstitutional votes. And so to the extent that either Congress or a court were to determine that particular votes were constitutionally required to be counted or constitutionally required not to be counted, it would actually violate the Constitution for the Electoral Count Act to require Congress to ignore those constitutionally required outcomes. And then finally, I don't know if this is a coherent argument or not, but something along the lines of an argument based on Powell v. McCormick and U.S. term limits versus Thornton, that Congress can't add through the Electoral Count Act to the requirements for counting electoral votes, that just like it can't add new qualifications, that just like it's whether your qualifications, whether in term limits, you're talking about the number of terms. In Thornton, you're talking, in Powell v. McCormick, you're talking about not being accused of bribery. Congress also can't add to the 12th Amendment's requirements for counting electoral votes. So to the extent that the Electoral Count Act says you're only allowed to count some subset of votes, that would be like adding to the specifications in the 12th Amendment. And so that would be unconstitutional. I don't know if that holds together well or not, but that would be the possible range of constitutional challenges I see to the Electoral Count Act.
Well, I saw Rick Pildus's hand up at one point. Did you take it down, or?
Yeah, I did, but I think I'll say something in response to Mike. I was just going to answer quickly your question about the vice president. I would assume that a majority of both chambers can overrule the vice president in this context, just like any parliamentary context. If the vice president's presiding and he makes a ruling about certain ballots, and the majority of the two chambers rejects that, that's what would prevail. I don't know what would happen politically, but I would think that they have the power to do that. But on the broader question that we're talking about, I guess the way I think about this is that we don't know whether the Electoral Count Act, would effectively have any weight with Congress. We don't know anything about how these constitutional questions might be answered. But what we do have with the Electoral Count Act is we have something of a focal point for a procedure for resolving these kinds of nightmare scenarios. And I don't know, from a democratic perspective, whether it matters if the governor, has the power to have his or her certified electors counted as compared to, the ability of the House and the Senate to reject the slate, blah, blah, blah. But I think in the context we're imagining, any kind of rule structure that can be put on the table and any greater clarity to the focal point that we have with the Electoral Count Act is desirable, because you're basically in a civil war context at this point, very close to it under our circumstances. And what we care about under these circumstances is whatever we can do to create some kind of ex-ante rule structure, whichever way it falls out. As I say, I have no political democratic theory views about the governor versus these other actors, but I do have a view that getting that clarified in advance to the extent it's possible to do so, and there are obviously limits to that, is very desirable. And so I would put to the side the questions. I mean, they are real questions, but from my perspective, when I think about this, I would put to the side the questions about its constitutionality. I would put aside the question of whether it will or will not actually have any teeth with Congress, and just say, this is what we have. Let's try to make it work as best we can to the extent we can clarify any of the ambiguities in some way that generates a set of, let's say 8 points about ambiguities in the act, and this is how we think they ought to be construed, and have something like that out there. I think that's as much as you can hope for. And it may be meaningless at the end of the day, or it may become a focal point in the midst of this kind of Civil War-like scenario.
Yeah, Rick, I think that's extremely helpful set of comments. So thank you for them. I think that says very well what the project of today's enterprise is, and also allows us to think about the prioritization of issues that might be useful with that lens. In other words, I share your sense of our goal now is to identify ex ante what issues can be usefully, constructively addressed in this time frame, and set aside those that can't. And so it's incumbent upon us as a group, to the extent that we want to do so, to create that priority list and put at the top the ones most likely to be constructive, and put at the bottoms the ones least likely, and try to use today's session at least to help guide that inquiry. So thank you for that. I'll just say one brief thing, and then I see some hands up, just on the procedure under the 12th Amendment, because if we go back to 1877, when Congress dealt with the Hayes-Tilden election of 1876, they did not have the Electoral Count Act at the time. That was adopted a decade later. And there was an objection to a ruling from the President of the Senate during the joint session. Again, this came very late in the process over a purported second certificate from the state of Vermont that the President of the Senate ruled as untimely, and that the Democrats were vociferously objecting to that ruling, and they thought it should have been on the table and had to be dealt with under the terms of the special election commission that existed at the time. Without getting too technical about that, what Congress discovered was that they had no parliamentary procedure for a joint session, that the Senate and the House can only act as separate parliamentary chambers, and there's no, they're never a unified body. So they never were capable to vote to override the ruling of the President of the Senate. Mathematically, since the objection was coming from the Democrats, and there were more Democrats than Republicans, if you added up all Senate and House members together, there might have been just enough members of Congress to overrule the President of the Senate, but he never let them take the vote, because he said there wasn't any procedural way for them to act as a joint session to do that. So I only say that by way of saying that I'm sympathetic with the notion that we're kind of stuck with the Electoral Count Act until or unless we amend it, unless people think there's a credible risk that in a real world scenario, someone's going to try to supersede it by saying it's invalid, and therefore we're just going to operate in a different procedural realm. But we're 4 minutes away from 2:30, and I see Joel and Josh, so let's go to the queue. Joel.
I was just going to add to, I think, Rick Pildus's point that in the 19th century, there were a number of instances where issues came before the Joint Assembly dealing with, say, whether or not to count a state's electoral votes, where there was a controversy as to whether it had become a state yet or not. And in each case, or in many of the cases, they decided to count them in the alternative. And so they basically sort of punted deciding the issue. And when you sort of read those discussions, you think, well, why didn't they sort of start creating some precedent at this point, so that they had some precedent in place and not wait until it actually mattered. And I think that the Electoral Count Act really was an effort to try and do in a way what you're concerned about is to minimize the controversy or to take a lot of these issues out of politics and to legalize them. I guess we'll get into it in the next round about your question about the role of the vice president, but it strikes me that if there's one thing that's clear from both the 12th Amendment and the Electoral Count Act, and that is that the vice president or the president of the Senate's role is to be very, very cabined and very de minimis throughout this whole procedure.
Josh.
So I want to follow up on something that Rick said as well. In terms of this being largely a political question that, and as Joel pointed out, could be infused by a legal argument, and that is to convince those legislators on the side of the candidate who lost to accept the result. And it reminds me of what happened here in Kentucky in 2019, when you had the incumbent governor who lost by about 5,000 votes, started suggesting that he might contest the election in the legislature, which would have the power to do whatever it wanted under the state constitution. And you had a lot of prominent people making an argument that this violated democratic norms because it would essentially be the legislature taking away the will of the electorate out from under them. And then that led to a few Republicans then sort of agreeing with that, and then that snowballed into finally the governor backing off. And so to create the kind of environment where you can convince the losing side that the democratic norms of the electorate's will, speaking. Now, this, of course, doesn't solve the interpretive questions of the Electoral Count Act, but I guess I agree that this is in many ways a political problem that you can use a legal resolution of respecting the will of the electorate to convince those on the losing side, at least some of those on the losing side, to accept the result. That can then add additional political pressure. And we saw that exact thing happen in Kentucky.
Yeah, good point. Well, we're at 2:30, so that's time for another half-hour break. So we're going to, again, suspend the discussion. If you want to turn off your mics and your video, we will start promptly. It'll be 3 o'clock Eastern. Again, right now it's 2:30 Eastern time. I guess that's 11:30 Pacific time. So we will start at 3 p.m. Eastern and at 12 noon Pacific. So see you in a half hour. Hello, welcome back to the final of our 3 sessions. We've had some great discussion so far, and I'm sure everyone's a little bit fatigued, but hopefully with a little bit of a break, we're re-energized for what hopefully is the most unlikely of our 3 scenarios or sessions, because the clock is ticking metaphorically towards Inauguration Day, January 20th, but in some sense, this session is the most important of the 3, because if a dispute lasts this long, it's most acute. So what I thought we should do is pick up where we very helpfully left off, thanks to Rick Pildes and his observation that we should try to prioritize those issues that perhaps we can identify as those really needing what he called ex ante clarification. In other words, this period now before November to try to hammer out. So I'd like to put one on the table. This is really a distillation of our scenario 3.1, and to see whether it falls into the category of something that we can say usefully how it should be handled. And so this returns us to the idea that in a single state, there are 2 separate submissions of electoral votes, one in favor of each major presidential candidate. So we could again invoke the Michigan scenario that we were talking about earlier, but there's a version of this from Pennsylvania or Arizona or Wisconsin, really Florida, if it's not necessarily the specific Florida example that we were doing, but another one. In any event, 2 different certificates of electoral votes from the same state. and it goes to Congress on January 6th. That's the date that Congress has specified for receiving electoral votes from the states. And what I want us to focus on is that they've invoked the Electoral Count Act. This is Section 3 USC 15. And there's objections to these two different certificates to the point where under the statute, the House and the Senate have separated and have debated for 2 hours the merits of these two alternatives. And let's say that politics prevails, partisanship prevails. And this is what happened again in 1876. So let's imagine the US Senate in control of the Republican Party, the US House of Representatives in control of the Democratic Party, and the US Senate votes in favor of accepting one certificate from Michigan, the one that favors President Trump's reelection, whereas the US House of Representatives, controlled by the Democrats, votes in favor of the different certificate, the one that says Vice President Biden as the Democratic candidate wins the state of Michigan. So you have that divide. Now, there's been debates about what the Electoral Count Act means. It's a complicated, convoluted, lengthy statute. One possibility is in that kind of situation where the Senate is on one side and the House is on the other, that whichever certificate is signed by the governor of the state is the tiebreaker, and that Congress must accept that one. Both chambers, the vice president is president of the Senate, no matter what, that there's an answer under the statute, and it means the governor prevails, essentially. So if Michigan is our example, that would mean, you know, the certificate signed by the governor of Michigan, presumably if it's in favor of the Democrats, Biden, that would be the answer. If the same dispute came out of Arizona, it might have the opposite partisan result. Do we think as a group that the correct understanding of the Electoral Count Act is that the governor controls in this way, no matter what certificate might have safe harbor status, no matter any other interpretive issue, as long as we're procedurally at that point where the Senate votes in favor of one certificate and the House votes in favor of the opposite certificate, that at that point, the correct legal answer is that the governor wins no matter what. Is that something that we as legal scholars understand the rule to be, or do we have disagreement or confusion on that point? John Fortier, I see your hand is up.
So, I mean, first I want to go back to Rick's comments and yours as well. And I'm in general agreement with the sentiment that we would be better off clarifying as much as we can before and not getting to this extreme situation of politics. But I will say we're already, you know, in these scenarios, there's a reason we've gotten to where we are in this very extreme circumstance. We would almost never want a state legislature to appoint a slate of electors. We would almost never want to have two slates of electors. I'm not saying that one party wasn't acting in bad faith, but certainly there is something happening that is extreme at this point, where there is a case that both parties are making that they feel the need to push it to this point. So while I would love to see a lot of this resolved by ex ante rules, I don't think that fits very well with the situation we're in. We're likely not, we're sort of blown past that in a way that it's going to be very difficult to see reasons for that. On the more specific point about the governor, I mean, so part of the problem with the Electoral Count Act, I mean, one, it's convoluted, so there are some loopholes in what you mean by certain things. And secondly, the you know, it's somewhat arbitrary in terms of a more general case of justice. If the point of the exercise was that the governor's certificate is the more regular one, because of course it came through the state and went through the normal course, the governor appointed electors, therefore that must get some precedence over whatever else. one could come up with a lot of scenarios where that might not be the case, from a rogue governor to 2 certificates the governors have appointed because, one under the duress of a court, or one earlier and one later with more information. And so, I think in this situation where we have a very extreme situation where people are making these claims of justice, and we have elected officials who, on one hand, actually, it's good that we have elected officials, because I think that it comes down to politics, and one has to justify oneself before the people and not do something that seems anti-democratic, seems to go against the will of the people. On the other hand, of course, it can be just that you're taking your own side. So I guess that's a long way of leading up to, I'm not comfortable with thinking that we should just always defer to this rule that it's the governor. And I guess I would say similarly on the safe harbor, there's some very good reasons for wanting to have this, and in most circumstances, that's where we should aim. But one could come up with scenarios where, again, we're at the extreme, and the reason we pushed it to this point was because there was something really amiss that one party is pushing. Whether they're right or not is another question. And that question of both the safe harbor and the governor becomes somewhat arbitrary. So I'd be in favor of having rules that you could just rely on. But I think we're at a point where it seems that, maybe that's not what people are likely to do, nor necessarily that's the right answer.
So thanks, John. Can I just push back a little bit? And given the premise of your point that we're in this situation, the parties would obviously be really at each other's throats, isn't the most important imperative that we have, as you say, a clear rule, a clear tiebreaker, whether we like it or not? So governor as tiebreaker may seem arbitrary, but if you make it more diffuse and amorphous and say, well, sometimes we'll let that part of the statute prevail, but sometimes we don't want it, and sometimes we want some other thing, isn't that the worst? I mean, we need to know on January 20th who's president. So if we don't have absolute clarity in the rules in advance, and we've got this partisan fight, what do we do?
Well, in some ways I would agree with you, but I guess I think that there's a lot of lack of clarity, again, what it means, the governor's certificate, and the difference between the early ones and the later ones. So again, if it really was just somehow, there are definitely circumstances where a governor's signature or a governor submitting it might be clearer than others. But again, what about the case of a egregious governor against what seems to be the rule of their state of what they should have done, appointing something early? Two governors with both appointing both certificates. I guess I think that there causes of justice here. The reason we've gotten to this point is because somebody really thinks something has gone wrong. Again, maybe they're wrong, but and the same people in Congress are going to be deciding this, or the same types of people, elected officials of both parties, and they're going to know about this injustice, and whether it rises to the level of going out and seemingly going against the people, or if they're arguing for the people. So if there would be some rules one might think are clear, but I guess I'm not 100% sure this is clear on the governor's part. And I mean, also the parties would know that they'd want to get the governor's signature somehow. And in some cases they might not be able to, but in other cases, it might empower a governor to just throw a slate of electors in there somewhat illegitimately anyway, just to kind of get themselves the up in the situation. So I guess I'm still a little uncomfortable that this is a great rule to rely on as a way of diffusing the tension.
Yeah, fair point. Lawrence.
I'm not sure if this helps to clarify the position that John was articulating, but it strikes me that maybe the binary that we're drawing between law on the one hand and politics on the other doesn't entirely describe the gravity of the situation that we're confronting right now, because it strikes me that rules can be very helpful in settling political disputes, but it does seem to be the case also that rules presuppose certain shared normative understandings. And maybe that's one of the things that we've seen eroding right now, is these shared normative understandings. And once these shared normative understandings erode, I'm not sure that rules are really in the position to solidify or to reinforce them. I mean, it strikes me really at the most basic level, if you're talking about the peaceful succession of presidential power, it's not something which is secured, or it's not something that's secured by our laws and our Constitution as much as it's presupposed by it. And once you have that kind of erosion of the normative underpinnings of the system, then it strikes me often that rules, I'm not sure if they're really are adequate to dealing with the problem.
Derek.
Yeah, so I guess, John, I share your concerns that there's always going to be some risk of some bad actor somewhere in this process, right? But again, I guess I'm sort of defaulting back to thinking, like, what is our solution here to handling these problems, right? And so while maybe we'd say, well, what about the rogue governor who doesn't deserve that sort of presumption of regularity? Well, that's why the chambers of Congress can step in and they have to agree, but they pick the other certificate. So in sort of Ned's hypothetical, there's going to be one chamber of Congress, right? So 51 to 218 or some votes that are siding with that sort of governor, that governor's decision that maybe we consider rogue. So I think there's more sort of political checks built in the system in the Electoral Count Act, maybe than we realize, or maybe we're skeptical that those political checks are the things that are going to work. In some ways, I like what the Electoral Count Act is doing, particularly after the election of 1872, where there's so many contested slates of certificates and votes, and there's decisions where one chamber essentially vetoes the selection of a slate of presidential electors. Getting back to something we talked about last session, I think to have default rules to count slates of electors, right? And that getting back to our sort of session one normative justification of we want votes to count, and when a slate of electors comes in representing the votes of the people, that's something that we should count, and it should take something extraordinary to overturn that. When it's competing slates, we just have to have some default rules in place, and maybe one set of default rules is going to always favor one set of rogue actors in some sense, right? But I guess I see there's enough sort of checks in this system, although people can point out the exploitation of that, I suppose, but to suggest it's never going to be one rogue actor, right? It's going to require multiple layers of actors acting in concert. And maybe we're concerned about that too, but then, I don't know, then it's rogue actors all the way down. I don't know.
Great. I'm watching the queue. I don't see any hands up. I'm looking for them. I'll just say this one quick thing. It seems to me as a practical matter, to build on Derek's point, that if both chambers of Congress agree as to which of two certificates to accept, then we're okay as a society, as long as the president of the Senate can't unilaterally override what both chambers want, which we'll get to potentially as a separate issue. The problem is if the Senate wants one thing and the House wants the other. Now, we're okay in that situation if there's only one certificate. According to the statute, one certificate has to prevail unless both chambers reject. So that's why the diciest situation is where you've got these two conflicting certificates and the Senate and the House are on opposite sides. So Lisa, you're next.
Thanks. One thing I keep thinking about, which I think is consistent with what a lot of people have been saying, relates to this concept that we refer to a lot in the election law field about the margin of litigation. And that's because if you are an election law lawyer or if you're a political consultant, you generally advise your client, you don't want to win by one vote. You want to win beyond the margin of litigation. And one of the things that these hypotheticals in our discussions just make so clear is that in a sense, this margin of litigation concept really should be expanded to sort of maybe, you use whatever sort of terminology you want for it, but to something like the margin for intransigence, which is to say that, the range of legal possibilities where there's an opportunity for both candidates to glom onto some sort of legal theory and both dig in their heels. And even though they're using legal language, they're actually not, in a sense, open to legal reasoning or legal argument. And it's in that range where we really, I think, start to get these problems. If you have the opportunity for litigation there, in a sense, that's actually very helpful because our court system is set up for this. You don't try to convince your adversary in a legal proceeding that you're right on the law. It's fine if that person insists that he's right. That's fine because you're trying to convince a judge. I think the problem with so many of these hypotheticals, for me at least, and certainly the ones for this third session, is there's not really a role for the court to play. And often the decision maker is, either the person who is himself or herself being intransigent about the law, or it's somebody who's closely aligned with that person. So I think that then kind of leads to the question that we've been grappling with, which is what's the role for law or for lawyers or legal academics when we're in this sort of space of legal intransigence, and people are, again, using legal terms and talking about legal things, but they're not actually open to legal reasoning. And I don't have the answer there. A few things that I can think of, which we've really touched on them all, but one is to try to do the legal work ahead of time to, in a sense, narrow that window, to say those things are not, the things that you're arguing there, you may want to argue them, but they're not reasonable. That's not a reasonable position for you to be insistent on. And we see that, for example, when the pandemic started, there was a sort of talk of the president canceling the election, and legal academics and others kind of came together and said, no, that's not a thing that can happen. That's not legal. One of the problems with what we're discussing, again, is that I don't know that there's clear answers in that way. So what else can you do? You can serve as essentially an advocate. You can, pick one side and advocate for various positions, translating legal arguments into things that you can put on Twitter or Facebook. You can advise, you can say something like, look, decision maker, you might think this is a good idea now, but if you thought about what this is going to do this Senate going forward, legally speaking. And then anyway, the last thing that I can think of is that it may make sense to, in the same way that you advise a client, look, you need to win beyond the margin of litigation, you can also say to the people who are involved, you need to win beyond the margin for intransigence. And what exactly does that mean? Well, we've been talking for hours about all the different places where we can have these problems. And one of the things that we can do perhaps is actually just flag those and say, those are the problems, we need to avoid those, because the truth of the matter is there's not a clear legal answer.
Yeah, helpful. Rick Pildes.
Yeah, so about the Electoral Count Act, I want to say that I don't pretend to be an expert on the act. I think probably very few of us are, maybe a couple of people on this list. The best article I know of on the act is the one by Steven Siegel. And this issue about whether the governor has the ultimate kind of decisive power in these nightmare scenarios we're talking about here is a very, very big issue. Actually, this is sort of where things really come to a head in the Electoral Count Act. And there's a dispute about how to read it on this point. Siegel is of the view that the governor does have the tie-breaking power when the House and the Senate disagree in the two-slate scenario. So I at least take that as a plausible position, and I'm not going to invest in the legislative history of the act, to the extent he has, and putting together all the pieces. It seems to me it's a plausible position, and therefore it's the position I would also push for, because we can't have a situation where the resolution of the election is indeterminate. And that's what Derek was saying. I mean, if it's actually the case that if the House and the Senate disagree, we have no idea what follows. We don't know what the denominator is for the number of electoral votes at that point. We don't know if the state in dispute, whether their electors count or don't count. This is a recipe for as bad a scenario as you can imagine. And so Siegel's conclusion that the governor does have the decisive power under the act as currently written is very attractive, I think, for avoiding that kind of ultimate situation. And so I endorse what Derek said. The only other thing I wanted to say, if we keep going to these issues of will the act matter or not matter, who knows? But I would put into the mix, in terms of the relationship of law to politics, that in a situation like this, where public opinion is also going to play a significant role in how all this gets worked out, to the extent the public is more convinced that one position is the law prior to the dispute, that can carry weight in the political struggle. So even if Congress isn't bound in some formal sense, and even if we don't know how much weight it will have, when you think about how the public reacts to perceptions of who's acting legally or illegally, again, that will be filtered through partisan lenses, to be sure, but we're only talking about the margins here. And at the margin, I think that can matter. And that's why I think getting clarity about an issue like this, what the statute is best understood to mean with respect to this critical issue of the governor's power ultimately, strikes me as an important point to focus on. And I think that is something we could make headway on, unlike trying to resolve in advance particular litigation contexts in which we don't know the 17 variables, that will be in play. This is a question of, what does the statute mean? And here's the best reading of it. And this is something that we are committing to in advance of knowing what effect this is going to have on particular winners or losers.
Yeah, great. Thank you. Sam?
Yes, to follow up on the previous 2 points from Rick and Lisa, we're in a situation where there is a role for clear exposition of legal rules, even though we don't know what the enforcement mechanism will be. And let me play out both of those. I too have read the Electoral Count Act. I found it confusing. I have not done the research on the legislative history. I can't tease it out. I think it would be tremendously helpful to have a consensus default rule that it is supposed to be the governor's signature on the certificates that ultimately is the resolution of a disputed list between two separate slates of electors. Why is that so? And now we get into the question that there's not a compelling legal authority. And here we're in the domain very broadly of what happens when you have law, but you don't have an independent arbiter who can enforce it. You don't have courts, because the same people who purportedly are going to be bound by it are going to be interpreting it. They are the people who can revise it, reject it, etc. But in game theoretic terms, it is really important to have a default rule because it raises the cost of defection. And so the most important thing that we can do here is to have something which has a putative claim on being the norm and being the normal response, so that people who want to act for purely partisan reasons, and of course, this is a partisan domain that will always be there, but those who want to act purely for partisan reasons have a legitimacy burden to overcome. And I think that that's in part what happened in the Kentucky gubernatorial election, as far as I can tell from outside, leaving aside that the governor himself was unpopular, but there was an illegitimacy stench to the way it was done because there was an accepted norm that pre-existed it. The difficulty with the Electoral Count Act is that it is obscure, it has never been put into force, it has never been tested, and it's been sitting there for 100+ years without any adaptation or any kind of institutional commitment, except for the fact that it is there. So I think that one of the things that can come from this is clarity on, if it were to come to two slates going into the Congress in January, this is the way the Electoral Count Act sets up presumptions. In a funny way, that's what the Supreme Court plurality was trying to do in Bush versus Gore. Now, they may have done it badly and all sorts of things, but they were trying to get a presumption of normalcy that would create the default position in an unprecedented contested domain. And I think that's the logic that we should follow.
Great, thanks, Sam. Adab, I think you're next.
I agree with all of the preceding comments, and I would only add that if we get to this worst case scenario with two competing slates, split party control of the two chambers of Congress, it's almost inconceivable to me that the Supreme Court doesn't decide that question. I mean, John Roberts, for all his reluctance to get involved in political disputes, the reason he doesn't like that is to build credibility for exactly situations like this. And there's no other mechanism to solve it. And I think the Supreme Court justices will weigh in, even if it's a 5-4 decision, before they'll let blood run in the streets. Now, maybe they will enforce the ECA, right? And they'll say the governor gets the tie break. Maybe they'll say, no, the ECA is unconstitutional because under the Constitution, state legislatures have plenary power, so they have to have the tie break. Maybe they'll say the president of the Senate decides unless he's overruled by a majority of senators. Maybe they'll say it's a political question, but be very clear about what it means, who wins, because it's a political question, the court will weigh in. But I think they will decide, and therefore, for all the reasons that everybody else has said, it's important to have the pre-established norm that they can either accept or the justices can deviate from, but it sets out the baseline for them to weigh when they take it, which I think they will.
Great, thanks. Paul?
I almost took my hand down because I was going to make the same basic point that Adav made. I do think that if we get to January 15th and the Congress is completely stalemated, there will be a Biden versus Trump lawsuit that will go directly to the Supreme Court, and they will rule. And I think the default rule of the governor's slate winning is very useful in that scenario, because even though it's weird to think of Congress being bound by a statute passed in the 19th century, you can think of the ECA as the rules that apply when Congress is unable to do anything to reach an outcome with the two houses working together to reach that outcome. And I think the court would find that an attractive rule to apply in that situation. I mean, admittedly, it's most likely to favor the Democrats in this situation, so maybe not. But given just where the splits in the states, governor and legislature, but I think we should strongly stand up for that as the tiebreaker rule.
John?
So maybe I've been helpful to the group because I've developed a kind of consensus against my point of view. So you can thank me for that. So again, I do want to come back to a couple things. I don't know that the governor rule resolves everything. Now, maybe we could say it resolves some things and therefore it's helpful. But again, nobody's discussed the possibility of two governor slates. And again, the ways to think of that happening are several. One being a governor owns a slate of electors based on some election results, maybe that favored his party or just following the election. And then a court orders the governor to, based on recounts or based on some other process that goes forward, to send another one in. Or perhaps there's just more information that the governor puts in later. A second point is, I do think it's not as if this rule is somehow a rule that one can't have some effect on, because it's going to entice governors in these dicey situations to make sure that they get some slate of electors in there. Maybe that's, I don't mean it's completely illegitimate, but if you feel like you have a case and you got a shot, maybe there's a sense that you want to, before a court tells you not to, or quickly, or with the blessing of your party, get a slate of electors in there. And again, that might be seen as pretty illegitimate by many other people, even though it's done by this person. So I guess I think that it opens up some other illegitimacy problems to just say, this is the this is what happens with the governor. Look, I hope we get to the other later question I will raise here, because I think it's a terrible place to be, right? When we're past January, we don't have resolution here. But I sense here that there's a wish that somebody would step in besides the legislature, or the fact that the legislature is going to just be deadlocked and disagree and not figure it out. And 1876 is a terrible precedent in many sorts of ways, although, when forced to, the parties came to some resolution. So, there's an argument that, this is an argument why it could be unconstitutional, which I don't necessarily agree with, but that Congress has this plenary power, and here we've gotten stuck, and we've put it to the political branch to try to resolve. Now I know there's a possibility they won't resolve it very well, but they will be subject to the pressures of seeming to look bad and needing to resolve this. We can also get to this question of, which again would be even more terrible, moving, not resolving it and moving to a successor and that sort of thing. What would follow after that? That would be very bad, although I have some thoughts about what to do about that. But I guess I put it on the table that, is this as clear as we think? It's somewhat arbitrary. It incentivizes some people to do some things that might be against, that it's just a clear, impartial rule. So I may be just getting more consensus against me, but those are my points to be careful about wanting to adopt this rule without really knowing the facts behind it.
Thanks, John. I appreciate that. Michael. Michael, you're muted.
Gotcha. Thank you. On the merits, I do think that the statute lays out the governor as the tiebreaker. I share the concern that John had mentioned, that it might create very bad ex ante incentives, that if the governor knows that he can shift some, or she can shift something away from just the one slate of electoral votes into these two competing slates, that then they would win if in case of Congress automatically disagreeing. I do worry about the ex ante incentives. As a matter of statutory interpretation, though, I find myself wholeheartedly agreeing with what appears to be the general consensus regarding the governor as the tiebreaker. The two things that I just wanted to emphasize here. The first thing is, before you get to the governor, you have a previous statutory determination that needs to be made, which is whether there has been a final determination by the state of any controversy or contest concerning its electors pursuant to the Safe Harbor Clause. And so one thing that I think is worth considering and addressing is, can the governor basically, through unilateral action, right, by let's say you have a state court saying, here's the final resolution of the issue, can the governor, just by certifying his or her own slate of electors, make that not count as a final determination? Or if the governor says, well, yes, I respect that's what the state court says, I'm a state constitutional law departmentalist, and so in exercising my own power, I wasn't party to that case, I'm not subject to any orders in that case, I'm certifying my own slate of electors. Now you have the governor generating conflicting, potentially conflicting resolutions to that final determination of any controversy. So I think even for me, the much more challenging question under Section 15 of the ECA isn't who wins the tie, it's when do you get to that tiebreaker role? What does or does not constitute a final determination of any controversy sufficient to allow one of the chambers of the Congress to either say there hasn't been a resolution, or there have been, but there are conflicting resolutions, and so therefore we need to go down and use this tiebreaker. The only other thing I'll briefly mention in response to Adav's point, I don't see any role for the courts here. Whether it's, John had mentioned sovereign immunity before, we could certainly throw in, right, the absence of a statutory cause of action, the political question doctrine. I don't know if the speech and debate clause would apply here, since it's not legislation, but it would be in the mix. I see a wide range of doctrinal impediments, jurisdictional, structural impediments to trying to put the Supreme Court or any federal court in the position of either enforcing the ECA, ordering Congress to comply with the ECA, or to do anything with regard to counting electoral votes. Right, the closest example we see of that is Powell v. McCormick, but even there, by the time it got to the Supreme Court, it was just a retrospective case for damages, and it was the clerk of the court and the doorkeeper and all these like non-members who were still the parties involved. So I don't even know that there would be a way to frame this in judicially cognizable terms. And I think that any attempt to do so would be butting up directly against the 12th Amendment and Article 2.
Yeah, so thank you, Michael. In fact, I want to sharpen Michael's point, if I might. I see Justin's hand up, but Justin, if you'll indulge me for a moment. And let's remember our very first session in our Pennsylvania, Philadelphia hypo, because I think there's a way to build on that to really get at this point about leaning on the governor as the tiebreaker under the ECA. Because if we remember that first hypo, we had the Pennsylvania Supreme Court being willing to deviate from the explicit language of the state statute in order to protect absentee voters who hadn't gotten their ballots. And again, whatever you might think about it, I want you to now assume that the federal judiciary, the US Supreme Court, has repudiated that state court decision and said, no, that can't be done. But you can imagine a scenario in which the governor of Pennsylvania backs the state Supreme Court and says, wait a second, there are all these Philadelphia voters who are registered voters. They didn't do anything wrong. They wanted to participate. And so I'm supporting them, and sends a certificate into Congress that says Vice President Biden wins Pennsylvania based on what we know to be these disenfranchised voters. Whereas in fact, the Trump electors vote on the authority of the federal US Supreme Court ruling. Again, we've got our two certificates, and moreover, the Trump electors claim safe harbor because they say they're appointed under the exact explicit language of the statute as it existed, that the federal court was insisting upon being followed, and it was the state Supreme Court that went rogue, and it was the governor that went rogue. So now we've got these two certificates in Congress on January 6th. We've got the House of Representatives supporting the Biden slate that the governor has signed. We've got the US Senate supporting the Trump slate and so, are we in a situation where Paul and Nadav say that the US Supreme Court can come in and insist that Congress pick one versus the other based on its own interpretation of the ECA? Or is this a situation where the governor, right or wrong, can muscle through and get its certificate adopted? I don't know if this is John's version of be careful of what you wish for when the governor signs a certificate, but I think it is a way to sharpen some of the difficulties with the statute and figuring out what our ultimate tiebreaker is. So I'll let that percolate and turn to Justin.
I actually would love to get responses to that issue because that strikes me as infinitely more problematic. I mean, I actually think this is part of the reason to say that I was going to agree with John not to assume that the gubernatorial tiebreaker is the be-all end-all, in the sense that there has to really be a tie in order for that to work. And John points out that there might be some scenarios that aren't really ties. Ned's might also be one of them, although I don't know which way I lean in that scenario. So that might suggest it is really a tie. I was going to bring up the notion that we have one governor who is, at least in some of these scenarios, has been bandied about as a putative vice presidential candidate. You might well have a governor who is on the ticket making this determination. And although I would think that would rightly, legally, responsibly call for a recusal of the governor in this scenario, right, to make that call. If the governor decided not to recuse him or herself, but was in fact decidedly self-interested in the outcome, literally, not just in a partisan sense, but literally, I would think that would be a scenario that John's sort of warning against, where the gubernatorial default is not the right default answer because there isn't actually a tie. That complicates things. That doesn't resolve anything. So, like Ned, I'll just throw another bomb into the works.
We'll throw the bomb to Sam for a little bit. Who's mute? There you go.
So I feel like we're at a very simple point of crafting legal rules. A default rule is a rule that carries you through 90% of the circumstances and admits bodies of equity to come in and figure out when they may not apply or when their logic doesn't hold. So self-interested behavior by a governor to create and manufacture a false double slate of electors, or to have a vice presidential candidate who is the governor of a state and who manipulates the rules to throw something to her own self-interest, well, that's something that can be rejected quite easily by whatever the top decider is. And usually it's a court, and courts are well equipped to deal with exceptions to default rules. And we know how the common law creates by accretion all these defaults. Here we're dealing with a political body where every situation will be one-off, but there will be much more political and moral latitude for a decider to say, I am rejecting the presumption in favor of the gubernatorial slate here because the governor manipulated this in her own interest. I don't think that you could ever write a legal rule if you had to make sure that it could never give rise to improper incentive structures. And I think that we have so much more to gain in this context by having a clear, fixed, presumptive default that, yes, we have 50 very smart people on this webinar, at least, and we could come up with lots and lots of hypotheticals where it fails. But right now, we're going into a very contested election with a pandemic out there, with the most polarized Congress in quite some time, and we don't have even the presumption of the default. And I think that's where we provide our highest service.
Thank you, Sam. That's very helpful. Paul.
To go back to Ned's variation of the Pennsylvania story, I'm basically agreeing with Sam. If you imagine that the state court decision opening up more voting in Pennsylvania goes up to the United States Supreme Court, and they immediately hold that it violates the federal due process clause to allow this additional voting and change the rules, it seems to me there's a number of things that are going to make it unlikely that you're going to end up with the two slates. But the governor at that point would be acting in defiance of a Supreme Court decision to submit a competing slate based on votes that had been held to violate the federal Constitution. If the governor nevertheless did that, there's a good chance that the House would not back it. If the House nevertheless did that, then I think there's no question that John Roberts and 5 justices would say, this is a place where we don't follow the default rule. We already told you that slate was not elected constitutionally. You know, Trump wins. That's just going to be the way it happens. It seems to me that is ultimately, to agree with Sam, there are exceptions to default rules, and one in which the slate was submitted in defiance of a final federal judgment based on the federal Constitution seems like a good exception.
Yeah, and I want to be clear, I'm just trying to play traffic cop on these issues, but I'm imagining in my version of that scenario, you've got civil rights groups talking about, widespread disenfranchisement of Philadelphia voters, not unlike the reaction that we saw to what happened in Milwaukee, right? In other words, even though the federal court would be coming down on the favor of follow the rules, even if that leaves voters disenfranchised, you'd have other folks saying that the election's been stolen from the people because the people were not allowed to vote. And so, yes, the rule of law equities side with, going with the federal court ruling, but you may have the governor may get some purchase saying, hey, I'm just doing what the people of Pennsylvania wanted if they only had been allowed to vote. I'm okay with that being the answer. I just want to be clear that the political dynamic of the situation may be people out in the streets protesting disenfranchisement of Philadelphia voters. Does that affect you, Paul, or no?
Well, no, I think that is likely in that situation because the Supreme Court decision that we've just been imagining, shutting down the effort to give additional days for people to have their ballots show up, exactly like was done in Wisconsin would be pretty awful and would seem awfully partisan.
And be 5-4, probably be 5-4 again.
It certainly would be. And, you have a situation where the reason for the problem was a violation of the law of Pennsylvania by the administrators who did not follow the 48-hour rule.
Exactly.
So you could make a good argument that the safe harbor rule doesn't actually support the outcome that, without the additional votes, there wasn't following the rules either. So I have no doubt that if the Supreme Court did that in November, there would be huge uproars about it, but they would have done it. And, maybe the governor would make himself a political spectacle of continuing to submit a slate in compliance with a state Supreme Court decision that had already been overruled. But ultimately, I think the answer is, Trump wins.
Okay. Joel.
Yeah, just a few things. I think with respect to Ned's hypothetical that I would guess that if the Supreme Court got in, that they would anticipate a lot of the issues that might come up and try and advise them or try and resolve them in advance. It strikes me that the governor's self-interest is somewhat different than the president of the Senate self-interest. In part because there's 50 governors who are involved and they're making a decision at an earlier stage in the process. I think in 1884, I think that Grover Cleveland certified New York's votes, which I think were decisive, and it was a narrow margin. And I'm sure there've been other instances where governors have certified on their own behalf. It strikes me, though, that I come back to thinking that the governor certification as dispositive rule makes sense, in part because even though you can imagine manipulation, if the governor manipulates a separate slate to get in the race, it still has to get the support of one of the houses of Congress. And so you have to imagine a lot of sort of inappropriate behavior before it even comes down to the governor's decision making the difference. When the 25th Amendment was being considered, Herbert Purnell used to say that that if one imagines that everybody's going to act in an improper way, that there's no possibility of coming up with rules that are going to work at all. And I think at a certain point, you have to sort of assume that if you come up with a rule, that it may have some advantage. And I think that the rule that the Electoral Count Act has here has some efficacy in that way.
Thanks. Norm.
So I just brainstorming a slightly different scenario from Paul, which is that the House refuses to accept what the Supreme Court did and basically says we're not going to accept any slate of electors from that state, meaning nobody gets 270 electoral votes. Now that may mean, and we don't know, because while the Republicans have a slight advantage in state delegations now, that may not hold. It could be that you don't get 26 states agreeing to resolve the issue of the presidency. We could see a very different scenario in the Senate as well. But if we got 5-4 decisions by the Supreme Court, widely seen as done on a partisan basis, I don't see the House accepting what the Supreme Court did. And they might say, you don't have the authority here. They might really challenge the fundamental legitimacy. I think they would just say, we don't accept that slate of electors, period.
Derek.
Well, I mean, building off of Norm's point and, showing my cards from what I've said earlier, I think Congress should feel free to ignore whatever the Supreme Court says in cases like these when it comes to counting the electoral votes, right? So Bush versus Gore is really back in scenario 1.1 land. It's this stuff where we're kind of figuring out the rules of which slate wins and what kind of, rules within the Constitution count. In my view, you read the transcript of members of the House attempting to object to the count of Florida's electors in 2001 in front of Vice President Gore, about as self-interested as you get. Like, in my view, perfectly legitimate act of Congress exercising its power to count electoral votes under the 12th Amendment. Now, the Supreme Court said, here's how the counting is going to take place. And it did. And now it comes up to Congress to review it. So all this is to say, you know, I'm a strong departmentalist thinking about the role of Congress here in terms of counting. To get into a point I think Lisa raised earlier, you know, I don't envision how these Title III lawsuits work after the House chooses to count or not count a slate of electoral votes. I can't imagine situations where the House shows up, says, well, you know, we conclude that Donald Trump or Joe Biden won. And then somebody running to a court and saying, hey, can you actually instruct Congress to find that the other candidate was the one who won, that they counted the votes wrong? I think I'm interested to see how the Supreme Court comes out in the Chiafalo and Baca cases, the faithless elector cases that they're deciding over the next couple of months, because part of this turns on decisions that Congress has already made in the 2017 counting of electoral votes that the Supreme Court is now being asked to take a look at. So I'm interested to look at that, but you know, not to be too much of a bomb thrower, but you know, I strongly support sort of the prerogative of Congress to make these decisions, particularly at these very late stages of the process, even when hotly disputed.
Mm-hmm. Rick Pildes.
I just want to make one point about the effectiveness, if you will, of these default rules or presumptive settlement mechanisms, which is, you know, think about the 1876 election. So Congress creates that commission, 15-member commission. Now it ends up being a different body than Congress thought it was going to be, because they had to substitute late in the day what turned out to be the decisive vote from the Supreme Court, which threw off the balance of that commission. Nonetheless, when the commission said that Hayes was the winner of the election, that led to further negotiation. There was the deal making about the federal troops in the South and kind of all of that. But that commission actually created a very powerful momentum for their resolution. Now, of course, Congress wasn't ultimately bound by the commission. You know, as Derek said, they could throw the commission out and do whatever they wanted to do, and no one was going to enforce the edict of the commission as against Congress. But you know, nonetheless, in about as intense a context as you can imagine, probably more intense than our current circumstance, though I don't know how to compare. Pretty high stakes, let's just say. That structure and the resolution generated by that commission had weight, a lot of weight.
Yeah, yeah, let's go to the queue. I see John next and then Paul.
All right, so I don't want to keep beating a dead horse, but a couple of things. One, in response to Rick's last point, look, I certainly don't want to see us get to the point where we have conflict and Congress is going to have to resolve this, but this commission was created by the facts on the ground and the parties agreeing to it at the time. The point about having this pre-existing, I would say somewhat arbitrary, somewhat unclear rule is that it was made before by other people, and that is what law is. But if you think that Congress ultimately is the one deciding this, them having to work out, maybe make a deal as to the structure of compromise, a commission, a set of rules on the ground, probably more realistic for the situation that the people would want to find a resolution among themselves than to defer to some rule that again seems somewhat arbitrary. The other point I guess I want to make is I think maybe we're, in the scenario certainly, but maybe generally we're thinking of it as an opposition between the legislature appointing the electors and then this other more normal process where the governor signs and I presume that means everybody's thinking we have an election and the election officials say it's the right thing to do. Maybe the courts say it's the right thing, and the governor kind of formally signs and passes it along versus the legislature stepping in this extraordinary way, which, you know, again, I think should almost never happen. But, you know, if we are in a situation like this, isn't the governor going to bless the legislature's view much of the time? So if the governor is of the same party as the legislature, and the legislature has felt that this is such an injustice or this something went so wrong that it needs to step in, the governor is of the same party as that legislature. Aren't they going to jump on the process right away, despite the fact that maybe the election process is going forward in a different way? The Secretary of State, the election officials, the courts might say, hey, the vote total is this over here, but for whatever set of terrible reasons the legislature wants to step in, is that governor going to be opposed to his or her own party in doing that? So I just worry that we're opposing those two things in a way that, practically speaking, I'd like to believe what Sam and Rick say about a default rule being true 90% of the time. I mean, this rule will be true more than that. In most elections, 51 election officials, election results will come in with the governor or whatever DC does, in the normal way. Even in odd cases, it will come in often with the governor's signature. But if you're really thinking about whether the state legislature is stepping in versus not, I don't know. I almost think it's 50-50 because that governor is probably going to side with the legislature. It's a deep political dispute here. And so I don't want people to think that they're putting their marker down as, hey, the legislature should really never be stepping in when you say the governor's signature is on this thing.
Paul.
I just wanted to make clear, I see a role for the Supreme Court only at the end stage, only in the situation where the Congress is just completely stalemated, which it could be with the two slate scenario. Just to respond to Norm's, as my understanding is, the House cannot disqualify a state's electoral votes unilaterally. The two houses have to agree to do that. And therefore, you get to this situation where the two houses are voting for two different slates and there is no dispute resolution mechanism within the Congress. That's where the court could do it. Now, maybe they'll figure out a way to negotiate it like they did in 1876 in some way, but that doesn't seem all that likely either, frankly. And so in that situation, it seems like, the court could not be overruling Congress, but be trying to give the country a way to have only one inauguration instead of two. In terms of what kind of a lawsuit it would be, it wouldn't be a lawsuit against Congress or against the House, or it would be the two candidates suing each other for a determination of which one is entitled to raise his right hand. Seems to me that works.
Paul, what I would say is you do have to get the two houses to agree, and if they disagree, the electoral votes for that state are not counted. The court, I don't think, plays any role in that circumstance and shouldn't and couldn't play any role. That would mean that nobody would get over the threshold of 270 electoral votes. If one house blocks an electoral vote count and the two houses cannot agree, then those electoral votes aren't counted when they count the electoral votes. Now, that would leave it up to the House to choose under the Constitution by state, with 26 states, a majority required, to certify a president. If not, it would be the Senate, and it'll be very interesting to see, one, what happens in the House elections in terms of state delegations, but two, what the new Senate would look like. So you could well get a vice president being selected who becomes the acting president at the appropriate time, or it could be left to the Speaker of the House.
Well, if that's true, if there is a dispute resolution mechanism that goes to the House, that's one thing. I was understanding the situation not to be resolvable that way, where the two houses are disagreeing about disputed slates.
This is kind of a two-finger. I mean, isn't it the case that both houses have to agree to reject a slate? That if the slate has been regularly given, or whatever the word regularly given, then you need both houses to reject it. And in fact, on the other flip side, you need both to agree that it's regularly given. So it does seem like if you have a dispute between the two houses, then the only dispute resolution mechanism in the statute is the governor's signature. And then if you have two that have the governor's signature, then you're backward. I don't know, people disagree over whether one has a governor's signature or not. I know that sounds crazy, but at that point, then, or let's say we're in a situation where the two houses of Congress agree and Vice President Pence disagrees, right? As the president in the Senate says, nope. And so I'm going to exercise my authority under Article 12 Amendment 12, to just count it myself, essentially. And so then you have two decisions by Congress. I can think of a lot of situations in which you would need the Supreme Court to step in, and as reluctant as they might be, I think as you approach January 20th and you have two administrations preparing for Inauguration Day, I agree that the court's not going to let the blood run in the streets.
Yeah, so I'm going to try to jump in here. I see two people's hands up, Josh and Lisa, that I want to get to. I also thought it might be useful to we can put up a slide of some of the language of 3 USC 15. It's a little bit nerve-wracking because the statute is so complicated, but this comes at the tail end of the statute where it says that if the two houses disagree with respect to counting of such votes, then in that case, the votes of the electors whose appointment shall have been certified by the executive of the state, meaning the governor, presumably under the seal thereof, shall be counted. Now, as Rick Pildes pointed out, there's some law review commentary which diverges over whether this single sentence from a much longer body of language applies sort of in all circumstances in which they're dueling conflicting certificates or only some subset thereof. But this is at least part of the statute. And I think with respect to Norm's question, we don't get to the 12th Amendment and the special procedure of the House having to vote like in 1824 because nobody's won 270 electoral votes if it's debatable, I think as Liza was talking about, as to who's won the contested state. And so if the gubernatorial tiebreaker provision applies, insisting that the governor's view prevails, then that certificate, that state will go into one candidate's column for purposes of reaching 270. So anyway, if we want to focus on the language, we can. In the meantime, Josh, I see your hand is raised.
I just wanted to add that I think in terms of going back again to first principles with respect to, a well-functioning democracy being based on the consent of the governed, that there should be a legal norm that rejects the possibility of a rejection of a state's electoral college votes. That was kind of clunky. But the basic point is that I think the default rule has to be that a state has electoral college votes counted and a dispute resolved one way or the other. I don't think the public would accept at all as a legitimate a result in which one state's electoral college votes is just tossed out. And so if you start with that as the legal principle, I think we can I think we should set aside or at least reject the idea that it's possible for a state to just simply not have their votes count at all. And then from there, we can figure out, okay, is it the governor's election under the governor's signature under the statute that controls? That's my reading of the statute. But I don't think we should accept a reading of the statute that preserves as legitimate just tossing out one state's votes.
Mm-hmm. Lisa.
I'm still hung up on the justiciability of a dispute before January 20th, although now that I'm thinking about it, it seems to me that once January 20th hits, then there's a lot of possibilities for bringing a lawsuit in the federal courts to figure out who is the president. And I guess what the candidates could try to do is bring a lawsuit beforehand, basically saying we want a resolution of that question beginning on the 20th, and we're going to sort of push the court to sort of relax its normal ripeness rules in a sense to decide that dispute. So maybe that's how it gets before the US Supreme Court. Again, I'm just really having a hard time understanding what that lawsuit looks like, particularly when we have a collection of federal judges who are increasingly seem to be resistant to deciding these sorts of disputes.
Justin.
Sorry, I don't want to skip over Lisa's point because I agree with it entirely. I think the justiciability of anything that's not after the 20th is really hard to figure out when it comes to the court counting. And in that extent, I agree entirely with Derek, who said a very similar thing earlier. I wanted to respond to Josh's point. So this is stepping back just a bit. I agree that the circumstances when we ought to have one electoral slate not count ought to be really, really, really small. That the number of circumstances leading to such a thing ought to be small, but not zero. And I come back again to what's the circumstance when an election as we understand it just doesn't happen? If we would, under normal circumstances, in a vote for a state legislature, for governor or something like that, would say we need a redo because nobody knows what the answer is. If we're running a race and the lights go out, you have no idea who crosses the finish line first. I think that the right answer in that circumstance might well be rejecting that slate's electoral votes, rather than simply deciding in a way that could be outcome determinative one way or another when you really don't know the answer. That it might turn out when the answer is, I don't know who won, to say, then we're just not going to count that state's electoral slate, rather than putting a thumb on the scale to have a decision simply because we need a decision. That is, there is actually a legal outcome to resolving a disputed election when you have not all states participating. And even when you have not a majority of the electoral college, right? We have decision rules for that. And so I only want to suggest that it needn't be, the default rule should absolutely be we count a state's electoral votes and we work as hard as we can to figure out which slate counts. But if the best answer at the end of the day is we don't know which that is, I don't think it's improper for Congress to decide, as unlikely in practice as it would be. I don't think it's improper for Congress to decide we have an election where we don't know who won, therefore we can't count that state's electoral slate.
But Justin, how do you separate the situation of Congress saying we legitimately don't know because of things that occurred, and one side of Congress saying we don't know because we want our guy to win?
Yeah, it's really hard. So it depends on whether we're talking about what a decider should do in looking at what the answer is versus what the right answer legally should be. If I were advising a member of Congress and saying, here's how you should cast your ballot in this disputed election context, and we don't really know what the answer is, I would not be advising that member of Congress, you gotta pick one.
So I think this is a very important point, and I'm watching the clock, and I want to reserve time to talk about this scenario and link it back to our Florida example. I think it also ties into the last scenario, which is, what if the vice president, as president of the Senate, does try to assert an interpretation of the 12th Amendment that gives that officer extra power to adjudicate some of these disputes. And so those are two lingering questions that I think deserve some attention on our part. I see a couple of hands up that I want to get to. I also want to ask, are there other folks who want to weigh in on the degree to which we should try now to speak to the gubernatorial tiebreaker scenario, or at least identify that as an item of fruitful further work? Because it does seem like, even if there isn't complete unanimity on this point, I'm hearing some large degree of consensus that this is something that's worth spending some more time on. We just may not have time on it today. So anybody else want to go to Barry next, because your hand is up, and I want to hear from you.
So two things to mention. One is on whether any state's electors should be rejected and whether the denominator of 538 should be reduced, which comes up in your scenario 3.3. Now, the 12th Amendment talks about the appointment of electors. It does not talk about the acceptance of them by the Senate or the Congress or anyone else. So presumably, and the legislature makes the appointment. So presumably the 538 holds because every legislature eventually is going to make an appointment of some kind. So that doesn't seem to leave a lot of room for reducing the denominator. We're discussing the controversies about the numerator, which I think are real. The second point is about the governor as the tiebreaker. It seems like a sensible rule because that person is the chief elected official in the state. They've won the popular vote. They have some authority, more authority maybe than a gerrymandered legislature does. But I mentioned in the comments, what about a governor, say Roy Cooper in North Carolina, gets booted from office this fall. He's mishandled the coronavirus and he, loses in a landslide. He still gets to be the tiebreaker there. Or we go back to someone like Paul LePage in Maine, who I think won his first election with 30-some% of the vote back in 2010. And that's part of the reason Maine went to ranked choice voting. Are you going to let a governor who won a third of the popular vote be the decider? And this gets to an article that Ned has written about the need for selection of electoral votes to be based on a majority winner in the popular vote, not a plurality winner. I think it's a reasonable argument. If that's going to be the standard for the popular vote, are we going to let a governor who didn't get a majority of the popular vote then pick electors? It seems inconsistent.
Good points. Yeah, I do want some discussion on this denominator issue because it's an important one. And even if we don't resolve it, I'd like some sense of all of you whether that is a candidate for further decision-making, because historically there have been two different views on how to calculate the denominator depending upon whether Congress tosses electoral votes from a state or not. John, did you want to address that issue or another one? We're coming up on 4:15 and we're going to take a hard stop on today at 4:30.
Yeah, I did want to address that, not my other point, which I've made, but one other thing too. So oddly enough, even though I'm not for a default rule in the other matter we're talking about, I think broadly speaking, we should be very careful, as Justin said, or Barry hinted at, that of reducing the denominator. There's several reasons for that, but I mean, one, the appointment of electors, there were a couple cases, I think, in 1796, very early on, where states basically just didn't get their act together and appoint electors, and they weren't counted. But as far as I know, we don't have cases of Congress effectively disenfranchising or disqualifying a state by throwing things out. Now, we do have the two slates issues in 1876, but we don't have...
I'm going to jump in there real quick. In 1872, both Louisiana and Arkansas, they were not outcome determinative on Grant's reelection, but there was a dispute over which way those two states went, and Congress punted on the denominator issue that year because it wouldn't have made a difference. But Congress contemplated addressing it and decided they couldn't decide it in that context.
So it hasn't, well, it hasn't been done. I think you're right about that. But I think the point is that I suppose there's always an exception, like there's to everything, but there is the difference between a state making an attempt to appoint and the idea of Congress finding some problem with the slate. So I would lean towards the idea that we would count the state as part of the denominator. A second reason for that is, and I just want to clarify what some of the parade of horribles is if we keep going on here. If we keep going on with the dispute, the possibilities are, or perhaps we go to this, contingent election that the House or Senate does. I think probably not in this case, but perhaps we're really deadlocking, and someone says, well, the rule says so-and-so should be president, or we get to January 20th and there is no resolution, and then we go to the Presidential Succession Act. And the reason I bring that up is that's a terrible thing. We wouldn't want to do that, but in an odd way, the Presidential Succession Act, if you get to that point, that person who takes over, it's still a temporary takeover. So whoever is third in line of succession now, it's the Speaker. Before, actually earlier, it was a different person when the Count Act was passed. That person is just sitting there until we resolve the election. Now, I suppose we think, what are the odds that we resolve this election on January 21st or February or March? But in theory, that person is a temporary caretaker. I had one more.
Yeah, I want to cut you off and put you at the bottom of the queue, John, if we have time, just because I see at least 3 other people, and we got to make sure we finish up. So hold the thought, John. I'm going to go to Joel next.
Well, with respect to the denominator issue, I actually agree with John that the situations in which a state's vote shouldn't be deemed to have been appointed are rare. I'm surprised, though, in looking at some of the times where it looks like the denominator has been lowered in the past, all in situations where it didn't matter, but some in the early part of the 19th century where it seemed that that somebody wouldn't show up and vote, and the denominator would be lowered. Ned, if it's appropriate, I was going to say something about the President of the Senate, unless that's not in order right now.
No, I'd go ahead. I mean, is this relevant to the January 20th and who's in charge kind of situation?
Well, yeah, I mean, in terms of just the role of the president of the Senate making a decision, I mean,
yes, go ahead.
Because I mean, it strikes me that that the idea that the president of the Senate, I mean, first, it seems to me that it's pretty clear that the president of the Senate gets to preside. The 12th Amendment doesn't say that the president of the Senate gets to preside. It simply says that the president of the Senate is the recipient of the votes and opens the votes. I think that the passive voice where it talks about the counting of the votes sort of suggests pretty strongly that the president of the Senate doesn't count the votes, but practice in the Electoral Count Act make it, I think, as clear as can be that the president of the Senate doesn't count the votes. It's hard to know what happened in the early 19th century, but at least by 1796 or 1800, the tellers were counting the votes. The president of the Senate, I mean, the whole structure of the 12th Amendment and of the Electoral Count Act really reflect the idea that the president of the Senate is really not supposed to have any sort of a significant role. I mean, you know, he receives the votes, but they come under seal, and a bunch of other people get the votes, so he can't sort of monkey around with the votes. There are multiple certificates that are sent. The president of the Senate has to call for objections. The president of the Senate announces the result that the tellers give him or her. The whole structure, I think, both of the amendment and the act suggests that the president of the Senate doesn't have any sort of a significant role. And
that's helpful, Joe. Without answering the following question, I leave it to the group to think about whether that's an issue that potentially could be litigated. In other words, if there were a dispute between the Vice President of the United States and Congress over this authority, is that something that the court would say is a political question and they can't handle it, or whether they would address it? But I appreciate, Joel, your weighing in on that. It's almost 4:20, so the clock is ticking. It's kind of like going down to noon on January 20th. We got to get these last points in. Michael, the floor is yours, and then we're going to go to Sam.
Sure. I'd just like to suggest, number one, there's a body of Senate precedents dealing with Senate election contests where they've looked at joint sessions of state legislatures and the parliamentary principles that govern the joint sessions that many jurisdictions used back when they had direct appointment of senators. So that might be a useful body of law to look to see what, if any, principles they applied in that context that might carry over to a joint congressional session. The only other thing I wanted to suggest on the denominator issue is Section 15 of the Electoral Count Act provides different grounds on which electoral votes might get rejected, right? So on the one hand, you can have Congress saying one or both chambers says that the votes weren't regularly given or by the electors, or that the electors' appointments were not lawfully certified by the state's executive. And so to the extent the deficiency isn't in the votes themselves, but rather is in the appointments, that if Congress were to conclude that certain electors weren't legally appointed for purposes of Section 15, then I think there's more of an argument there for not counting them as part of the denominator that you need to reach the absolute majority. And then in the situation where you have multiple slates, but only one of them was submitted by the safe harbor, then again, Congress has to determine whether these votes were lawful under state law. And that seems to me to be at least broad enough or mushy enough to give Congress the authority to say, we don't think these electors were lawfully appointed under state law due to all of these problems with the underlying election. And so again, if they were to reject the slate, depending on their grounds for doing so, that could adjust the denominator. So I think just given how complex Section 15 is and the different off-ramps for potentially Congress taking action, it might depend on why Congress did what it did to determine whether or not the denominator is affected.
Okay, great. Sam.
So on the question of the denominator, the way I come at this is that anytime you have a regulation, there's two types of error, type 1, type 2. And what you have to address, what do you think the principal worry is in the United States right now in 2020? And it seems to me that the principal concern is the extreme partisanship in Congress, and that any soft spot in the rules might be an incentive for partisan manipulation in order to try to game the outcome of the system. And so I am less concerned about the various scenarios in which the electors and the process in the state might be compromised, so much as I am that any mechanism that seems to invite a reduction in the denominator is an invitation to partisan revisiting of groups of electors so as to try to manipulate the outcome. So here again, I think that we should not try to think through every possible circumstance where something might need to be addressed and try to have a fixed rule ahead of time or compromise a fixed rule if it can't address it, but rather the real need is for fixing as many of these rules as hard as can be ahead of time, because again, I think that the main concern we have right now is such partisan dysfunction in Congress that any play in the joints will be an invitation to attempted manipulation.
Yeah, thanks, Sam. And in a minute we're going to wrap up, but there's one more thought I'd like us to at least ask you if you want to weigh in on. It goes back to Rick Pildis's categorization of issues that should be put on that priority list. Sam's just put the denominator point as one to clear up ahead of time. We've been working our way all day today from Election Day, November 3rd, through the meeting of the electors in December, January 6th, when Congress meets. We've alluded to Inauguration Day being on January 20th. On our priority list of things to worry about now, how much should we worry about the possibility that noon on January 20th might arrive with both sides still claiming victory for whatever reason of the scenario? I know Lisa, I think, said that she could imagine lawsuits happening after January 20th. But who do the generals give the nuclear codes to starting at noon? Do we have to think through just that transition of power question if both sides are still in dispute the morning of January 20th, or is that something that just is too speculative and should fall off our priority list? Liza, I see your hand is raised on this point.
Yeah, I think we'd be remiss if we didn't think about it. It's not that it's likely, but I think for the first time potentially in modern history, it is possible. And so I think we would be remiss to not think about it. In the scenario, the question was whose command should the military follow on January 20th? I think the concern is less whose command they will follow on the 20th. I mean, that is the concern, but really you need to back up and say before the 20th and the weeks approaching the 20th, as you still have two administrations vying for the presidency, that's when Trump is still clearly commander-in-chief, and that's when I would worry about the deployment of the military, because at that point, the military has no question whom it is supposed to obey. And so my concern would be less about commands being given to deploy the military on January 20th, but rather deploying them using the Insurrection Act to deploy the military based on a claim by President Trump that we were seeing an insurrection by, by Congress or whoever it is that has the Supreme Court, whoever it is who has designated Biden as the winner. If that has happened, then this would be called an insurrection, that Trump would deploy the military at a time when he is still very clearly the commander-in-chief, and that deployment could create a reality on the ground that would be hard to change simply by the clock striking midnight on the 20th.
Yeah, so just one real quick follow-up directed to you, Liza, on that. I mean, suppose that there is actually clarity in Congress that both chambers agree that Biden has won, but that President Trump has tried to do something in that intervening period, issued orders of some kind, wouldn't the generals immediately follow the directive from a bicameral Congress saying now on noon on January 20th, it's President Biden, no longer President Trump? Wouldn't that end the matter in terms of the transition issue?
Well, I mean, again, it's ultimately the military is going to be faced with this question of whose command they are supposed to follow. If Trump says that he is their commander in chief and Congress says he is not, the commander in chief power is an Article 2 power that Congress does not have the power to constrain, right? So if that is a purely Article 2 power. So to the extent that Trump is purporting to be exercising a power as commander in chief to repel an insurrection, and he says Congress is trying to take that power away from me.
Dakota, I see our colleague here at Ohio State who's an expert on military law. Please have the last word on our behalf before I thank everybody on this point, Dakota.
Well, that's a weighty responsibility, and unfortunately, I don't have much cheery to say. Both to Liza's point about presidential orders related to the Insurrection Act, or potentially something like martial law. Ned, as you've written about, that President Grant was contemplating in 1877, and then also this question of who gets the nuclear codes, who gets the nuclear football. I mean, both of this has a nexus in one of the dynamics that we have, which is that the armed forces are part of the executive branch, and they get not only orders from the commander in chief, but they also get legal guidance through the executive branch. And the way that normally works, you have the Attorney General or OLC or the General Counsel at the Defense Department provides guidance on matters of statutory interpretation of the Constitution or whatever as it relates to normal military stuff. And those can generate really interesting issues, but that's pretty typical. What we're talking about here is a profoundly different kind of legal question, which is the question about who gets to give the military orders. And there's just inherent risk for, this is unlike 1876 in the sense that you have an incumbent who's running for re-election. And so if the incumbent and the Attorney General or other political appointees who works for the president says, well, armed forces, our guidance is that we won, it's just an inherent appearance of self-dealing in political power, in constitutional power, right? I mean, that's just a profoundly different type of legal question that the administration and the Justice Department and DOD, an Office of General Counsel, would be trying to answer than they usually do as they work with the military.
So it's 4:30. I'm sorry, Dakota, it is 4:30. I think the only thing I can say in my defense is that we didn't run out of things to talk about, and we didn't allocate too much time for today. Maybe we didn't allocate enough, but I expect we're all a little fatigued. And it seems to me that the question that we collectively should ask is the one that we put on the table at the outset, which is, is further work valuable? It doesn't necessarily have to mean Zoom meetings. It could be sharing drafts of documents, who knows? Obviously, Steve and I will look into that. We welcome input from everybody who attended or observed today. Again, we're agnostic as to what the next steps should be, but we're open to thinking about next steps. The thing that I think is absolutely essential to do before we say goodbye to everybody is to thank folks at OSU. There are too many folks who've been involved for me to name all of them. The Mershon Center, which Dakota is part of, has been helpful in planning this. But one person stands out other than Steve. Steve hasn't spoken for a few minutes, but I think I'm speaking on behalf of both of us, where we thank Jillian Thompson, who has come on board with election law at Moritz to help run our program between now and November. And she's done just a fantastic job in getting ready for today's event. And she's been the master of ceremonies behind the scenes in terms of making the whole thing work. So if we were all there in that round room together, I think we'd be giving Jillian a standing ovation. So I hope we can do as much of that as possible through this Zoom-based technology. With that, I want to, again, hope that I will talk in different formats with all of you, but I want to promise to let you go. So I'm going to say goodbye and thank you to all of our participants. I'm going to thank our audience for being patient, especially because they were on that perimeter of the room just observing. I hope people have found today valuable, but I want candid feedback of all types. And Steve, do you want any last word to sign off? Steve says no, so goodbye, everybody. Thank you all so very, very much.